Gentleman from Jackson.
Thank you, Mr. Speaker. I note the absence of a quorum.
Mr. Clerk, would you please open the board and let the members note their presence? Lady from right.
Thank you, Mr. Speaker. Announcement of special guests.
Please proceed.
Thank you, Mr. Speaker. Mr. Speaker, to your right and my left, at the second column, is my sister, the other lady from right. And many of us have our loved ones who make it possible for us to serve 37,000 people in our hometowns and home communities. And Sarah plays a huge role in making my service possible. And I ask that the body join me in giving her a warm welcome.
Gentleman from Pulaski.
Thank you, Mr. Speaker. Introduction of special guest.
Please proceed.
Mr. Speaker, to my left and your right, between the second and third column, is a very special person. He's the manager of the ice cream factory. That's not Central Dairy. That's the place across from Central Dairy. And he's an excellent young man, a fantastic manager. We expect great things from him. He's terrible at guessing people's ages, however. And if the body would join me, make him feel welcome. Thank you very much.
Gentleman from St. Louis City.
Thank you, Mr. Speaker. Introduction of special guests.
Please proceed.
Thank you. Thank you. To my right and your left, between the third and fourth column, we have the mayor of the city of St. Louis, Mr. Shara Jones here. She is a former representative, was a treasurer of the city of St. Louis for several years, and she's the first black African-American mayor that we had in the city of St. Louis. So if the body can make her feel welcome, outside of her also being my bigger sister, I would greatly appreciate it. Thank you.
Welcome back to the House, Representative. Representative from St. Louis City, Aldridge District, do you wish to note your presence? Has everybody voted? Mr. Clerk, would you please call the absentees?
Atchison, Baker, Bland Manlove, Boggs, Brown 87, Bouchite Courtway, Burton, Barnes, Cristofanelli, Clemens, Dahl, Ely, Evans, Hine, Mackey, Mann, Morris, Myers, Nixon Clark, Pfeiffer, Prouty, Ritchie, Riggs, Schnelting, Smith 163, Strickler, and Young.
Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 76 yea, 62 present, you've established a quorum. Gentleman from Jackson.
Thank you, Mr. Speaker. Next order of business will be House Bills for Perfection Informal. And I ask you to recognize the lady from Buchanan for a motion on House Committee Substitute for House Bill 115.
Lady from Buchanan.
Thank you, Mr. Speaker. I move that House Bill 115 be perfected and printed.
The lady from Buchanan has moved for the perfection and printing of House Bill 115. Lady from Buchanan.
Thank you, Mr. Speaker. I move that the House Committee Substitute for House Bill 115 be adopted.
The lady from Buchanan has moved for the adoption of the House Committee Substitute for House Bill 115. Lady from Buchanan.
Thank you, Mr. Speaker. I move that the title of House Committee Substitute for House Bill 115-99 be adopted.
The lady from Buchanan has moved for the adoption of the title for House Committee Substitute to House Bill 115 and 99. Is there any discussion concerning the title? Seeing none, all those in favor of adopting the title, please signify by saying aye. Aye. And those opposed, no. And the ayes have it. You've adopted the title. Lady from Buchanan.
Thank you, Mr. Speaker. House Bill 115 and 99 is legislation that allows our constituents to have direct access to physical therapy services. That means when a patient wakes up and they treat their back or they wake up with a stiff neck, they have the option of receiving physical therapy care immediately. Currently, an individual suffering from these painful, yes, really relatively common minor conditions are required first to make an appointment with their physician, then see their physician and get a prescription for physical therapy, and then they have to make an appointment with their physical therapist before they can finally see their physical therapist. And we all know that this process could take 1 to 2 weeks or even more, and the entire time the patient is suffering from pain. The result is higher cost, time, and frustration for the patient, and delayed treatment, which really leads to worse outcomes. Recent studies have shown that states with direct access of physical therapy, and let me make it clear, 47 other states have direct access to physical therapy, as well as the District of Columbia and the Virgin Islands. Those states that have direct access to physical therapy show they have fewer visits and less overall cost. This bill simply allows patients to make a choice where they receive their health care, and they can pick their provider from the beginning. Physical therapists have very extensive education and clinical training. They know how to do examinations, evaluations, diagnosis, and prognosis, the interventions of patients with functional limitations, impairments, and disabilities. And all accredited entry-level physical therapist education programs result in a doctorate of physical therapy. And physical therapists are qualified to recognize when a patient presents with signs and symptoms inconsistent or outside the scope or expertise of the physical therapist, and when the patient should be referred to a physician. This legislation hopefully we will amend later today, will allow a patient to visit a physical therapist 10 times within 30 calendar days before the physical therapist must consult with a physician. But in those 10 visits or 30 days, if that patient is not seeing any results that resemble the work that a physical therapist would normally see, they're required to refer that patient to a physician, and they must stop all treatment. The states surrounding Missouri have direct access, and we are losing our physical therapists to those states that are surrounding Missouri. And our constituents are having to leave the state of Missouri to be able to see their physical therapist when they want to have direct access. I think that we should make Missouri competitive with our neighboring states and allow our constituents the opportunity to seek health care that they desire, and in the meantime save money and get their lives back free of pain. With that, Mr. Speaker, I have an amendment to offer, and it's ending in point 03H. It's been distributed, and I ask for its adoption.
The lady from Buchanan has moved for the adoption of House Amendment 1. Lady from Buchanan.
Thank you, Mr. Speaker. We have been consistently working with the medical associations to make sure that we can have everyone on agreement on this bill. And the language that I'm presenting in the amendment, excuse me, Mr. Speaker, can I have a little bit of order? I'm having trouble hearing myself think.
Members, please keep your conversations to a low minimum so we can debate the bills. Lady from Buchanan.
Thank you. I appreciate it. Sorry to have conversations stop, but they're right in my ear. So anyway, thank you very much. So on this amendment, Mr. Speaker, it's been approved by the Senate. They adopted it. It really has very insignificant language in it. The only language that you see that is different than what is there is it was 10 visits within 21 working days. The physicians asked it to change it to 10 visits in 30 calendar days. That is not very, there's really no difference in time that, but we were making that consistent. So that is the amendment, and with that, Mr. Speaker, I move for its adoption.
Further discussion on House Amendment 1. Seeing none, the lady from Buchanan has moved for the adoption of House Amendment 1. All those in favor, please signify by saying aye. Aye. And those opposed, no. And the ayes have it. You've adopted House Amendment 1. Further discussion on House Committee Substitute House Bills 115 and 99 as amended. Gentleman from Jackson.
Thank you, Mr. Speaker. To speak on the bill.
Please proceed.
Thank you, Mr. Speaker. The gentlelady from Buchanan did a wonderful job of explaining this bill. We've seen it several times here in this chamber. We have passed it out several times. Unfortunately, it always seems to stall when it goes across to the other chamber. It's a very good bill. It gives patients direct access to physical therapists. It's a much-needed bill. I'm going to support it, and I'm going to ask the body to support it as well. Thank you, Mr. Speaker.
Further discussion. Lady from St. Louis County.
Thank you, Mr. Speaker. Speak on the bill.
Please proceed.
Thank you. As the only physical therapist on the floor today, the representative from the Dahl District, unfortunately to her great disappointment, is not here today. I think this is a good bill. I have actually lost business in my small private practice physical therapy because when somebody would call me and say, I want to see you, I'd say you have to see the physician first. So physical therapists today get a doctorate in physical therapy, and we cannot see people walking in our door. However, if you're a massage therapist and you go to school for 9 months, you can hang a shingle out that says, I see you for back pain. And so we were allowing our massage therapists to do what the state of Missouri has not allowed physical therapists to do. In case you're not sure that physical therapists know what they're doing, I'd like to tell you about one of my experiences. I had a woman that was post-op breast cancer, and then one of the common side effects of that is lymphedema. So you have the side of the breast that had surgery, that arm gets very swollen. And so my referral said lymphedema, and the woman walked in, and I said, let me see your hands. And she gave me both her hands. And it's usually quite easy to see somebody with lymphedema. It's 1.5 to 2 times the size. Well, her arms were exactly the same. And I thought, well, okay, this doesn't match the diagnosis. Okay. Well, what kinds of problems have you been having? She says, well, I'm having trouble raising my arm, and I can't get my arm up very high. So I thought, well, maybe she has a shoulder issue because she certainly doesn't have lymphedema. And I said, okay, and what kind of challenges are you having? And she explained a little bit more. And she said sometimes she's getting a little bit of numbness and a tingling. Well, none of that makes sense. And I said, well, what else is going on for you? She says, well, recently I've started stumbling. Well, talk about throwing a red flag up in the air. So that makes no sense that she was starting to stumble. And then the last thing she told me, and I have a severe headache, and she put her hand at the back of her neck and she said, I've had a severe headache for the last couple of weeks. And I said, well, you know what? I'm not going to see you today. I'm not going to treat you today. I think you need to go back to see your physician. And after you do that, please let me know how and what they've had to say, and I'm happy to have you back. Well, about a week later, her daughter called, who had been with me. They left my office and went directly to the emergency room, told them what their symptoms were. They did a brain scan. She had a brain tumor. And within the week that I was called, she'd already had surgery. She was already recovering. We really know our job. We really know when not to see somebody because we spend the time talking to them about what they need, what their issues are, what their concerns are, what their problems are. And then the other is called a mechanism of injury. How did you hurt yourself? Well, this woman's, her case just told me that I wasn't going to see her that day. So we've worked for quite a few years. Yes, this side of the building has passed this bill, goodness, the lady of the sponsor, I think 5 or 6 years. And so I appreciate that the Senate has already passed this, slightly different, but it looks like finally this is going to go through. And maybe I'll stop losing business, losing opportunities to see people when I tell them they have to get a referral. So I'm wholeheartedly in support of this bill. Thank you, Mr. Speaker.
Further discussion. Gentleman from Jackson.
Thank you, Mr. Speaker. To speak in favor of the bill.
Please proceed.
Thank you. This bill has come through professional registration and licensing since I've been here for the last 5 years. And we have passed this bill out of professional registration and licensing each time, and it has come to the floor. And to the previous representative's information, I will agree with her that it has come, we have passed it out of this body each time. Just a quick note that this time, however, we had no opposition from the physicians groups. So I just want to know that in closing, I am definitely behind this bill because for once in my life, I'm not going to have to go to my doctor or pay him the co-fee and for him to tell me it's okay to go to my therapist. So I would ask the body to please join me in voting for this bill. Thank you.
Further discussion. Seeing none, lady from Buchanan, you're recognized to close.
Thank you, Mr. Speaker. I am not a physical therapist, and people often ask me, why am I so passionate about this? 6.5 years ago, my life changed forever when I had a hemorrhagic stroke, which was a brain bleed. If it wasn't for the days and weeks and months that I spent with my physical therapist, I wouldn't have the opportunity today to be in this beautiful chamber presenting this piece of legislation. I often say I am so grateful for my doctors and my great medical care because they saved my life. But my physical therapists, they gave me my life back. I have witnessed their work, I know their abilities, and I have seen their passion to make sure that clients get their lives back. I see no reason to make the people wait to receive care from a physical therapist. And there is no reason why Missouri is the most restrictive state for people to be able to have physical therapy care. With that, Mr. Speaker, I close.
The lady from Buchanan has renewed her motion that House Committee Substitute to House Bills 115 and 99 as amended be adopted. All those in favor, please signify by saying aye. And those opposed, no. And the ayes have it. You've adopted the House Committee Substitute to House Bills 115 and 99. Lady from Buchanan.
Thank you, Mr. Speaker. I renew my motion.
The lady from Buchanan has renewed her motion that House Committee Substitute to House Bills 115 and 99 as amended be ordered, perfected, and printed. All those in favor will vote yes. All those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 141 yea and 1 nay, you have ordered House Committee Substitute to House Bills 115 and 99 as amended, perfected, and printed. Gentleman from Jackson.
Thank you, Mr. Speaker. Moving to House Bills for perfection, and I ask you to recognize the gentleman from Jasper to renew his motion on House Committee Substitute for House Bill 301.
Gentleman from Jasper.
Thank you, Mr. Speaker. I renew my motion.
Gentleman from Jasper.
Thank you, Mr. Speaker. House Committee Substitute for House Bill 301 addresses a number of items in the arena of crime for the state. I want to give you a little background as to how we got here before I start talking about the specifics of the bill. During the interim, you asked me to chair a working group on crime. And we agreed that in dealing with crime, because of the diversity in our state, there was a necessity that this be something as bipartisan as we could make it. The working group consisted of 6 people, 3 Democrats and 3 Republicans. We made a good faith effort to find compromise, to listen to one another, and to do the conscionable thing. As a result of that, a bill came out that was filed as 301, and it contained a number of specifics that we thought we had to address. Among those things we had to address were 2 things in particular. One had to do with creating the Special Prosecutor's Office for urban areas, and secondly, dealing with the question of children with guns. Now, we knew from the very beginning when we had those conversations, every time we talked about the provision related to guns, we knew that that was going to be difficult on our side of the aisle. Nonetheless, that was the committee's recommendation. As the chair of the committee, I felt a responsibility to create a bill that reflected what they had decided. So I filed House Bill 301, and in committee, we had nearly a 5-hour discussion. Ultimately, in that discussion, the provisions related to guns did not survive. The committee voted down an underlying amendment and then created some new amendments that resulted in the bill you have before you today. As the chair of that committee, a number of people have asked me to try to restore some of the provisions of the original bill, and I've declined to do so to the extent that I conscionably can. I don't think it's appropriate for the chair of any committee to circumvent the committee's will and start imposing my own will. So this bill, while it looks a great deal like the original bill, does not contain any provision of any kind related to firearms. And I know a lot of you have heard that and have been concerned about it. I want to assure you that is not in this bill. The genesis for this bill is quite simple. Crime in our state, crime across the nation is a concern, but particularly in our urban areas, where at this point, at least one of our communities has a per capita crime rate that more than doubles the per capita crime rate of Chicago. I've been told that I should not be meddling in this community's business. And I would submit to you and anyone else who wants to listen, I'm not a meddler, I'm not an outsider, I am a Missourian. In the past 5 years, 1,043 Missourians have died in the city limits of St. Louis. That is not acceptable. It would matter nowhere in the state where such a thing occurred, it would still not be acceptable. So House Bill 301 begins with the idea in mind that we're going to create a special prosecutor. The governor would have the appointment to appoint a special prosecutor if, after reviewing federal, state, and local crime statistics, or if the homicide cases per 100,000 people exceeded 35. Under those circumstances, that would trigger the governor's authority to appoint a special prosecutor. That special prosecutor would have sole and exclusive jurisdiction over first and second degree murder, first and second degree assault, first and second degree robbery, and vehicle hijacking wherein a firearm was used in the commission of that crime. That office would retain sole and exclusive jurisdiction over any other event coming out of the underlying conduct. So if there was a case that descended from that, it would remain with the special prosecutor. The bill also provides for services for inmates. In particular, the department will help them get prepared for release by helping them, not doing for them, but helping them with birth certificates, state identification, making application for Medicaid. The idea being that we would like to help them be a success when they get out of our correctional facilities. We also provide some conditions for release. Just releasing somebody back into society doesn't mean they're going to be successful. If someone is going to have the privilege of early release, it is in their best interest as well as the state's if those individuals were prepared for work on the outside. And so there are some discussion in this bill about jobs and job training and providing certificates of completion of those trainings, things that would help them when they apply for a job when they're on the outside. There's also a provision in here commonly referred to as truth in sentencing. Many of the people, particularly the sheriff's departments, are concerned that they are seeing the same people over and over and over again because the sentence applied to those people sounds good on paper but is meaningless in practicality. They're getting out early to reoffend, and particularly getting out early to reoffend without benefit of some of the training and conditions that corrections could offer them. We have a piece involving unlawful firearm offenses. This bill provides that a school officer commissioned by the district board or school protection officer, as described under section 160.665, shall not be prohibited from carrying a firearm into any school, onto any bus, or onto the premises of any function or activity sponsored by that board or district. And again, the issue here is not about creating something new, but ensuring those folks who are charged with protecting our schools have the ability to do so without being in conflict with existing law. This bill also deals with reimbursement for police academy training. We passed a similar bill out of this body last year, and we heard it the year before as well. Right now, we have about, I think it's 21 different police academies. Of those, a significant number are run by academic institutions, and in fact, the majority of them are run by academic institutions. When someone applies for the academy right now, the academic institution is concerned with really only two elements. One is, do they have any prohibiting criminal background, and can they pay the tuition? If so, they can attend the police academy. When people graduate from the police academy, then and only then can they receive a license and make an application for law enforcement employment. The difficulty there is that the vetting process that leads to successful employment occurs after academy graduation. There are a number of cities in the state that have their own academies. St. Louis, Independence, Springfield, Kansas City. And these are organizations, and the State Patrol. These are organizations who vet the employee up front and then send them to the academy. So right now what happens in those academic environments, they get out, they get a job, or they apply for a job and find out they don't qualify. They'll run into trouble in background checks. They'll have financial issues. Maybe they can consume too much alcohol, or when they get to the polygraph, there's something that they haven't been telling folks. Maybe they've got some difficulty in relationship with their neighbors. What happens then is a significant number, sometimes as much as half, does not become employed. And so we've utilized those seats, and we've yielded no product that's going to help with law enforcement. And many of the others may have limited aptitude. They will get jobs with agencies that can't afford to pay for quality folks, and then wind up committing a lot of case law for the rest of us. So what this bill does is allow people to complete the academy, which costs about $6,000. They are then able to, each year for 4 years, submit for reimbursement for 25% of the cost of the academy. This is dependent on them getting the job and maintaining the job. It does nothing for those who don't become employed, but it does allow somebody who is, say, a minority, somebody who's low income, somebody who's 35, 40 years old, decide they want to be a police officer because they know what life has to offer them, but they're also saddled with mortgages, children, and can't afford to incur a $6,000 debt with no guarantee of a job. This is our intention that will broaden the pool of applicants, and hopefully raise the quality of those officers. With that, Mr. Speaker, I have an amendment. Amendment ends in 2.33H. It has been distributed. I move for its adoption.
The gentleman from Jasper has moved for the adoption of House Amendment 1. Further discussion. Gentleman from Jasper.
Thank you, Mr. Speaker. This bill makes some changes in the underlying bill that are both clarifying, and we want to make sure that we stay within our constitutional boundaries. There was some concern early on that perhaps having a committee make this selection might run us afoul of the separation of powers. And while I don't necessarily think that's an issue, I also don't think that I want to put the concept at risk. And so the language has been changed to say that if the governor determines that a threat to public safety and health exists in a circuit or prosecuting attorney's jurisdiction after reviewing federal, state, or local crime statistics, or find a number of occurrences of homicide cases, it's important to understand we're talking about cases, not singular homicides, because any kind of multiple homicide could skew that data. The number of cases in the 12 months immediately preceding exceeds the rate of 35 cases per every 100,000 people within the circuit or prosecuting attorney's jurisdiction. The governor may, and it is his option or her option, appoint a special prosecutor who shall serve for a period of up to 5 years. The special prosecutor shall be employed at the will of the governor, shall not be required to reside in the jurisdiction of which he or she is appointed to serve, and shall be an attorney but shall not be the attorney general or assistant attorney general. The language also provides for when an inmate is released, that individual is presented with a certificate confirming their training that complies with the statute. This is also the one that provides that the department will help the individual apply for Medicaid if they qualify. This also deals with the truth in sentencing question. It is important to understand, I know a lot of people had some concern that there were mandatory minimums in here. That language has been removed. We may see it again at some other date, but it is not in this bill. This also retains a provision, the other gentleman from Jasper, the Smith District, worked several years ago to make sure that a judge could depart from minimum sentencing provided that certain findings of fact were present. It would allow them that, and I think that's important that we save our jail space for those who belong there. Judges should have that option. This also deals with instructors at the police academy, ensuring that they are approved by the post authorities. With that, Mr. Speaker, I think I'm prepared to take questions.
Further discussion on House Amendment 1. Gentleman from Pulaski.
Thank you, Mr. Speaker. To inquire of the bill sponsor.
Does the bill sponsor yield?
I do.
Good afternoon, gentlemen.
Good afternoon.
How are you doing?
I'm glad to be here, frankly.
First of all, I want to thank you for bringing this bill forward to begin with. I think you and I agree that crime in our state's a serious problem, and that means we have to do something pretty serious to address it. Would you say that's correct?
Yes.
And I appreciate your amendment, too. I think it makes it a lot simpler. I think it really gets back to the issue of the special prosecutor and how we're addressing accountability for those violent crimes. I want to ask you a few questions about your amendment and then a series of questions about the background of the bill coming out of committee, if that's okay.
That'd be fine.
All right, so you talked about that there's a truth in sentencing provision. There was some language before, and then a new set of language was added in committee. Is that right?
That's correct.
And then we've taken out in this amendment the language that was added in committee, and we're going back to what our colleague had for mandatory minimum truth in sentencing language that was before. Is that right?
That's correct.
And then I recall one of the issues was that there was a retroactive provision that said it would apply to crimes that were adjudicated after 2003, and that was an ex post facto problem. This amendment doesn't have that ex post facto problem. Is that correct?
Correct, yes.
Okay, thank you. And then I want to talk about the committee selecting the special prosecutor versus the governor. Can you walk us through just a little more the pros and cons of maybe the benefits of the direct selection by the governor, and then some of the benefits of the committee, and then the shortfalls with the committee as well, if you don't mind?
Okay. So I think it's important to understand that beginning at the very inception of the working group, we were focused on trying to make sure that we were inclusive, that we did things that considered everybody's concerns. The prosecutors, as you might expect, had some concern about the idea that we're going to appoint a special prosecutor. When you're talking about things like prosecutorial discretion and prosecutorial independence, you're treading on pretty sacred ground. And so the idea that we are somehow encroaching on what is a mainstay of the judicial system, we didn't do it lightly, and we spoke to everybody. As you might expect, the prosecutors in particular were not especially thrilled with this concept. And while I appreciate that, we felt that it was important that we actually move forward on this, and so we made an effort to try to massage the language to be as palatable to the associations as we could. And in that effort, we came up with this concept that the governor would appoint a committee of prosecutors who in turn, when asked by the governor, would provide a name for the governor, he or she, to appoint as the special prosecutor. There are a number of folks whose judgment I respect greatly who suggested that that treads awfully close to the boundaries of separation of powers. And even though, from my non-legal perspective, I had a little trouble feeling that, I just wasn't willing to take the chance with something that's as important as this. I'm hoping that whatever we do here has the ability to implement and have some immediate resolution, because every day, when you talk about 200 people a day dying in a single jurisdiction, how many days do you wait before we actually do something? So there's a sense of urgency on my part that we actually achieve something that we can implement in a short period of time. And I thought this might somehow facilitate their acceptance of the idea. Ultimately, it's just not something that they were able to live with. And in order to comply with the concerns about separation, I've returned to the original language, which leaves that authority with the governor. That authority is provided by the threshold. That authority is at their discretion. It may not require it. So the effort was, again, to make sure that we crafted language that worked. This language is much the same as the original language, but not exactly. It's not the sole discretion of the prosecutors. It's not a hybrid. It is clearly the purview of the governor.
And I appreciate that we are also changing something. It's a pretty big deal, which is that the prosecutorial system in Missouri. And so you're saying that committee was an effort to try to lessen the shock of the change a little bit.
Yes.
But there's a concern that it might be unconstitutional, even the way it's worded.
Correct.
And do you recall, we had discussions in committee, we've had discussions through it, we also had discussion about, and I'll go with the opinion that I had, that who bears responsibility, who does the buck stop with, and there might be some value, do you think, or could you comment to, that if we say the governor is the one who's the actuator of this situation, the governor will have political responsibility to the state of Missouri for if he or she decides to appoint the special prosecutor or not. You think there's some goodness in that? Could you comment on that, please?
Absolutely. And here we're providing a government official with the authority to do something that is really impactful to a local community. The review of the data, the decision to determine whether or not the threshold has been met lies with the person making that appointment. In this case, that's the governor. And so the buck truly does stop there. It's the governor who has to agree, yes, the threshold has been met, yes, I've reviewed the data, and yes, I've determined that a public safety problem exists, and I hereby appoint. It is a one-person decision. He or she may get a lot of guidance from a lot of people, but when all is said and done, this is the governor's decision and the governor's responsibility.
And I actually like that. I think that the decision maker should be somebody who's accountable to the voters, that is imbued with elected authority. And I appreciate it. I think this has been a really good process, that we've taken something that's a hard problem and we've really drilled down, and I appreciate that. I want to ask you a few more questions about the background and give you an opportunity to explain kind of, what came out of the committee through the working group, if you don't mind. So you said that all the provisions that related to gun control have been taken out of this bill,
That's
right?
correct.
So there's nothing here on the floor that we could construe as restricting Second Amendment rights or an individual's right to protect themselves. Is that right?
Correct.
And I recall, I think we've had a positive committee experience where the idea that we all had was that each of us can act in accordance with our conscience. And I appreciate that idea that maybe we have different consciences and different takes on it. Could you just walk the body through sort of the background of how that came about, and whatever thoughts, whatever elucidation you want to give the body about why we have this product that's here and what the result is, so they kind of have the background on that?
Thank you. So when you're talking about guns in the state of Missouri, again, you're talking about a pretty sacred concept. The Second Amendment in this nation, and I just want to be clear, there's people on the floor who love the Second Amendment as much as I do, but there's absolutely nobody on this floor who loves it more than I do. The Second Amendment is so uniquely American that it is part of our international identity, it's part of our national identity. Nowhere else in history or in the world have the people given themselves the right to keep and bear arms. So anytime you brush up against that amendment and you start causing friction, it becomes a concern for everybody. And where the bright line exists, where you step over or not, is not necessarily the same for everyone. So in the city of St. Louis in particular, but I know that other urban areas are having some of the same problems, maybe not to the same degree, but they're very similar in nature. When you have young people with guns, and when I say young people, I'm not necessarily talking about juveniles, the teenager, although that can be problematic as well. For those of you on the floor, remember the decisions you made when you were a teenager. We're talking about when you make those kind of decisions with a gun in your hand. But I'm also talking about children, 8 years old, 10 years old, 12 years old, 14 years old, who are walking around urban streets with a handgun, either in their hand or on their person. And it begs the question, why would a 14-year-old have a Glock 40 in their waistband? If you were to see a 14-year-old in a Walmart with a Glock 40 in their waistband, would anybody on this floor not be concerned? Well, of course you would. Well, what would you do about it? Well, you'd call the police. And the police would show up and they would say, what do you want me to do about it? Because there is no prohibition. The prohibitions that may have previously existed no longer exist. That has left the police to have to bootstrap ways to deal with this sort of thing. I had a police officer in my office actually yesterday. And what he said was, and I'm going to soften it a bit because he was a little emotional, but when we talk about preserving the Second Amendment, which is important to all of us, he's the one who lives with the reality. I'm the one who's going to shoot the 12-year-old and have to live with that. So while the rest of us can think about these things in terms of the importance of the Second Amendment, there are some real-world consequences to other people when we do that. So what we were left to do was try to craft something that would address that kind of unique circumstance where children have guns, children with no life experience, to understand the consequences of what they're doing with that handgun. And unlike those of us whose parents gave them a gun when you were 8 or 9 and taught you gun safety and how to be responsible with the gun, The 12-year-old with a Glock didn't get that guidance. I'd almost guarantee it, because his parents wouldn't turn him loose on the street with that gun. So what's he doing out there? What is a 14-year-old or a 12-year-old doing with a Glock 40? Well, I'll tell you what they're doing with it. It's for self-defense because somebody has threatened them, and a gun seems like the easy answer. Well, it certainly looks good on TV and on the video. Or they're going to intimidate somebody with it. They're going to be the problem instead of the solution to the problem. Or they're going to commit a crime. Or they just think they look pretty darn cool packing a gun. None of that has the potential for a good outcome. There are reasons why, and I had somebody explain to me, if you live in St. Louis and you have to walk to school everybody by a group of people older and bigger than you who try to intimidate you, well, then a gun probably makes sense to you. But if you're an adult and you understand the consequences of that, you might take a different route. So we're really talking about people who don't have the life experience to make the decision associated with having a firearm on the person. When all was said and done, the question of hunting, the question of Second Amendment rights, we distilled down to a single document. And those of you who've been watching Facebook know that I've been referred to in a number of different adjectives, not all of which are complimentary, and that I'm taking away people's guns. What the amendment said was, under the age of 18, on a public street, with a handgun, not a rifle, on your physical possession, not just in the car with you, readily capable of being immediately discharged, and without adult supervision. It had nothing whatsoever to do with taking guns from law-abiding citizens. That wasn't the purpose in the first place. The members of the St. Louis Police Department will tell you they really want this, because right now they're faced with this increasing crime wave, and a critical element of it and their ability to respond is missing. That was the intent. It was never meant to transgress the Second Amendment. However, the committee did not see it that way. And I understand that. Again, we're really talking about something that is near and dear to all of our hearts. But the committee voted it down. As I said earlier, I think it's inappropriate as the committee chair for me to have the committee vote out a bill and then I go back and change it according to my wishes or because others want me to do it on their behalf. I think that needs to be done by this body if it's going to be done at all. And so it is not included in this legislation. There is no gun legislation. There's no ammunition legislation. It's not in this bill.
I thank you for giving us the background. And I know that there's a real problem that you have an approach to solving it. I think a lot of us do. We want to take it different ways. And I appreciate the chance to let the members of the committee express themselves and vote their conscience. And I know that there are a lot of problems we got to work together on. I will say, for the sake of the body too, if I were able to say something to the body, that there are definitely some things that we want to come here and compromise on. But for each of us, there's something that we can't compromise on. And all of us have to decide when that point is. When you're not, what value are you not going to compromise? And so it's for each of us to decide. And we're all elected because we're going to find that decision point for ourselves. But I do appreciate the discussion, and I appreciate the background on that, and I look forward to supporting a bill that addresses what I think the problem is. And I want to remind everybody the problem is that people who are committing acts of violence aren't being held accountable. And that's creating a serious crime, it's contributing to a serious crime problem in our state. So this is going to be hopefully part of the solution, part of the puzzle for us addressing that. And I'm excited to be able to work with you on that, Representative, and thank you for taking the inquiry.
Well, I want to say to you and to the other members of the committee, there are approximately, and I'm going to focus on St. Louis because it's the highlight example, but it's happening elsewhere in our state, but in St. Louis, approximately 200 people a year are dying, and the people who are taking those lives are not in jail. That's not okay. Those people are now free to reoffend and put everybody at risk again. I spent my life in public safety, and when I look at something like that and I have people say, well, you need to wait, see whether or not our new policies or maybe our new personnel fix the problem. Or you need to butt out. You don't live in St. Louis. What do you know about our community? I absolutely reject the idea that as a Missourian, I'm supposed to watch 200 people a year die, and because I don't live there, I should have nothing to say about it. We are state representatives.
Gentlemen, you're out of time. Further discussion on House Amendment 1. Gentleman from Dent.
Thank you, Mr. Speaker. I have an amendment to an amendment. I have House Amendment number 69H to House Amendment 33H.
The gentleman from Dent has moved for the adoption of House Amendment 1 to House Amendment 1. Gentleman from Dent.
Thank you, Mr. Speaker. After reviewing the bill that is currently being talked about, there's come to my conclusion that there's several pieces of language in here that need to be clarified and be more consistent with the current law. And that's in two different sections. One of them it states violent misdemeanor offenses. That is not currently in our statute or addressed in statute. So we're going to change that. It doesn't change the definition. It just puts it more clear and more consistent with the law we have currently. And we're going to change that to misdemeanor offenses involving a crime of violence. So that's one section on there. There's also a section in there that we were talking about that has nonviolent felonies. Well, there's no definition for that in the statute as we speak either. So all we're doing now is changing it to the wordage of dangerous felony, which we currently have legislation on the books for that. So just basically clarifying these two phrases to make it consistent with the law. So there's no really changes in the bill itself. We're just trying to make it as clear as possible and have it mimic our current statutes that we have or phrases we have in the law. And with that, Mr. Speaker, I'll take any questions.
Further discussions on House Amendment 1 to House Amendment 1. Gentleman from Jasper.
Thank you, Mr. Speaker. The amendment maker has spoken with me about this. He's pointed out where those discrepancies and needs exist. I agree with him and I support his amendment.
Further discussion on House Amendment 1 to House Amendment 1. Lady from Gentleman from Taney.
Thank you, Mr. Speaker. To speak on the amendment to the amendment.
Please proceed.
Thank you, Mr. Speaker. I appreciate the cleanup language of this amendment to the amendment. Sometimes we make things a little bit too complicated, and I think this does a great job in clearing up some language that could be misconstrued. House Bill 301 was thoroughly vetted in your Crime Prevention and Public Safety Committee. Concerns were addressed, amendments and solutions were promoted. But, Mr. Speaker, attempts were made to disenfranchise some communities by limiting or curtailing their Second Amendment rights, and that could be construed as a form of disfranchising a group of people. Shall not be infringed applies to all people, all Americans, despite geographic location. Those of us who love liberty, who defend American freedoms, are ever vigilant in defense of constitutional guarantees. The Second Amendment was not drafted to defend those who hunt squirrels or shoot targets. The Second Amendment, the protector of the First, was designed that citizens may thwart any attempt by a tyrannical government to subvert the will of the people. The Second Amendment guarantees that we might defend ourselves, our loved ones, and not simply rely on a local police force or established military. A well-regulated militia suggests that individual citizens might gather in the defense of liberty. Here in Missouri, laws like Stand Your Ground, which need to be enhanced, and the Second Amendment Preservation Act help guarantee our liberty, our freedoms as Missouri citizens. Myself and other members on the Crime Prevention and Public Safety Committee thoroughly debated, discussed, and vetted House Bill 301. We stopped bad amendments, especially those that would seek to curtail Second Amendment rights or provided many ways to be soft on crime. Mr. Speaker, certain areas in our state have major problems and have failed to get a handle on crime. Lack of prosecutions and a revolving door system of justice have not made our streets safer, but conversely have made certain areas of the state places not safe to live in or visit. Poverty, lack of educational freedom, and the destruction of the nuclear family contribute to societal problems. Mr. Speaker, we have a problem in certain areas of Missouri. House Bill 301 does not solve all the problems, but would help provide to that office that can't seem to prosecute crimes in their community. There are aspects of the bill that help reduce recidivism. There are also aspects of House Bill 301 that I'm not 100% in favor of, but I and others are not willing to throw the baby out with the bathwater. The bill has been vetted. We on the committee have looked over it line by line and judged it worthy in the main of passage in this body. No bill is perfect, and quite probably the solutions are multifaceted and may take lifetimes. But today, now, we can do what elected representatives are called to do: secure liberty and provide help to those in need in our state. I encourage the passage of House Bill 301. Thank you, Mr. Speaker.
Further discussion on House Amendment 1 to House Amendment 1. Lady from St. Louis County? Nope. Okay. Gentleman from Pike.
Thank you, Mr. Speaker. To inquire of the amendment maker.
Does the amendment maker yield?
The amendment to the amendment maker.
I yield.
Please
good afternoon, gentlemen.
Good afternoon.
So, I serve on the committee that has been hearing these bills and vetting these amendments, and we've had some spirited conversation, and I think we have brought to something that has been well vetted. And so I would just ask if you could clarify a little more about your amendment, because we didn't get an opportunity to hear that much. If I could talk to you just a little bit more about what your amendment does.
Oh, basically, right now in statute, there's no such definition of violent misdemeanor, right? That's not in statute. So that's not addressed in this bill. But there's a current, language, there's current language in the law that kind of addresses the same thing, and it's misdemeanor offenses involving a crime of violence. So all I was doing was, instead of having another definition in our state statute of violent misdemeanor offense, why not use the current language that's already in the law? So it was just a cleanup, so we don't have to have two different, this is a violent misdemeanor, this is a misdemeanor offense involving a crime of violence. Which do you go by, So I'm just trying to make it consistent with the language we already have. And both those involve that, because I had nonviolent felon, and now it's a dangerous felon, which already has a definition.
And this is something that you noticed on your own as you were reading through.
Well, one of these parts of this bill went to committee as a bill to judiciary, and the representative from Howell brought it to my attention that the misdemeanor offenses of crime, violent crime, was already in language. So he corrected that in his committee. So I brought that to the bill sponsor and said, I think we probably should have the same language in that particular bill if it's in this current legislation as well.
So you would say that it's just being consistent with previous definitions?
Yeah, I would like to say, we think all these things out here to do, and we come up with these nonviolent felons. Well, we don't have a definition for that. But we do have a definition in statute of dangerous felonies, so it's pretty more cut and clear on who we're talking about. If we say nonviolent felons, now there's no list of that or no crimes of that. So this kind of clears it up. Some of it is still subjective on the misdemeanor crimes of violence, but that bill only kind of gives reference to the judges when it's coming to a certain issue. They have to consider that particular crime. That's not adding any penalties to that.
And I trust that you took this to the chairman fairly recently and got a chance to visit with him on it.
And, it come to my attention after all this got done, which was yesterday. We was talking about adding a committee sub on his, but he said it might be easier if I added these clear up language on their own so I can explain them.
I see. Mr. Chairman, Mr. Speaker.
Further discussion.
To inquire now of the amendment maker.
Does the gentleman from Jasper yield?
I do.
Please proceed.
Thank you. Good afternoon. You have spoken to the amendment maker. Do you believe that this language is necessary in your amendment to make it more understandable and to be consistent with what already exists.
I think the goal is to provide consistency. The amendment maker has a long history in law enforcement, understands that, as many people have said, words matter. And so I think his efforts to make this consistent with existing law and to clarify any conflicts we might see in the future is well-intentioned. I trust his judgment.
All right, thank you, sir. Thank you, Mr. Speaker.
Further discussion on House Amendment 1 to House Amendment 1. Seeing none, gentleman from Dent, you are recognized to close.
And I close.
The gentleman from Dent has moved for the adoption of House Amendment 1 to House Amendment 1. All those in favor will signify by saying aye, and those opposed no. And the ayes have it. You've adopted House Amendment 1 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Urban Cole.
Thank you, Mr. Speaker. I offer amendment to the Amendment 1 ending in 2.76 and move for its adoption.
The gentleman from Cole has moved for the adoption of House Amendment 2 to House Amendment 1. Gentleman from Cole.
Yes, Mr. Speaker. This bill basically stops. This bill was originally designed and passed last year through the Houses on preventing disclosure of public personal information for purposes to harass and intimidate. We heard the Supreme Court judges today talk about how important it is for this bill and how their personal information can be disseminated and be used to threaten, harass, or intimidate them in making their decisions. This bill goes one step further, and it applies to all elected officials. Each of you have a right to have your children's personal information kept private. You should not use your personal information to intimidate you, harass you. That's also true, and I've seen with county clerks and that who are being harassed. And so this bill generally is a bill that was basically passed last year, but again was highlighted by Missouri Supreme Court of the need for this bill. That I will take whatever questions.
Further discussion. Gentleman from Texas.
Mr. Speaker, permission to inquire from the amendment sponsor.
Does the gentleman from Cole yield?
Yes, sir.
Good evening, gentlemen. How are you today?
I'm doing fine.
Thank you for bringing this forward. Did you say this was a bill last year? And if it was it heard in committee? Or?
It was heard in committee. In fact, this bill was heard last week in our committee. We didn't vote on it yet, but there was no one spoke in opposition to it.
Okay, what committee?
And last year was in Judiciary, and this year was in Judiciary.
Okay. And obviously we heard discussion about this today. Have you seen instances in the past where it make it necessary for this amendment to be necessary to be on this House bill today?
Well, I've seen it where people made comments, but myself about one of my kids, but that was mainly, I don't think they were out to intimidate me. They just wanted to embarrass me. But I also heard from other representatives where it's happening to our county clerks, and especially with the voter IDs and all that going on, we're having threats to them. And basically, this bill just wants to set that protection there so we can get our guidelines before it gets out of control.
Okay. And you said it applies to all elected officials? Is that?
Yes.
Okay. Is it?
Prosecutors have a bill, but that it would affect them also. And you have public defenders who get threats. I know I personally had some very unpleasant things posted about me when I was appointed to represent someone who had less than ideal characteristics.
Okay.
And then we got an acquittal.
Would this also apply to our municipal elected officials?
Yes.
It would, okay.
All this bill is stopping to do is publishing personal information for the wrong purpose.
Okay. So you said municipal, county. Does this apply to our health boards as well, or?
Elected officials.
All elected officials.
Correct.
Okay. So if you're an elected official in the state of Missouri, this would apply to you?
Yes, and I didn't feel that I should pass a bill that said that no one can say that about me as an elected official and some other elected official. They're fair game. It's across the board, and again, it's not a very older thing. It is just you just cannot do these things for the wrong purpose, with intent to harass or try to influence them in a certain way.
Okay, and I didn't have a chance to look through it all yet, but what are the penalties? What goes into this?
Well, for the judges, the penalties are a little higher. The judges, if you look at it, deal with tampering with a judge is a Class D felony, and if it results in death or injury, it is a Class B felony. Now, for other elected officials, we're not that serious. It is basically a Class A misdemeanor, which can be up to a year in jail. But also, if they do it for the purpose to influence an elected official in the performance of such officials' official duties, the offense is a Class D felony. And that, again, is giving the prosecutor some discretion as to what to do. Like any crime or set of crimes, the prosecutor can look at it whether it's a Class A misdemeanor or a Class D felony.
Okay. And so you...
And keep in, I guess... Well,
no, proceed.
Go ahead.
Okay. So you said last year this bill came before a committee, and was it voted out? Or?
Yes.
It was. And so...
Now, let me rephrase that. I think I got to go back, there's 2 years. No, it was passed out. 1 year we didn't have that in there about other elected officials, and we didn't have the legislature in there. And this year we made it for all elected officials.
Okay. So this has been something that's been around for a while now.
It's been around and a growing problem, a serious enough problem that a Supreme Court judge takes time out to bring it to our attention.
Yeah, very true. I mean, can you go into that some more? He discussed that this morning with us, but have you had any other discussions with any other elected officials about this piece?
Well, yes. I mean, this was not just my brilliant idea. This came from Missouri Bar and some other representatives talking about county clerks being harassed and that over the elections. And therefore, we just decided that, let's make it fair for all elected officials, because in this day and age, you may be just the sheriff, and they want to post a whole bunch of stuff. The public defender, who is here defending someone who certain people don't like, and they want to take their shots at him. So again, it covers a lot of area, but as you can see, it's a Class A misdemeanor or a Class D felony, but it's enough to give teeth into something to stop it from happening.
Well, I appreciate you bringing this forward. And is there anything else that you want to mention about this to kind of let me know and the rest of us know about this, how important this is to this House bill?
Well, as you can see, the Supreme Court judges think it's very important, and so do a lot of county clerks with the series of stuff we had about the elections and that. And it's just uncalled for conduct. And the day is now when public dissemination of information is so easily to have, we have to have some guidelines or rails on how much it can go.
Very true. All right. Well, thank you very much for the inquiry.
Thank you.
Gentleman from Jasper.
Thank you, Mr. Speaker. There are a number of us on this floor who understands what it means to have people try to intimidate you, and their access to your public information certainly facilitates that. This is an excellent amendment. We heard it this morning from the Chief Justice, and he was right about everything that he said. I support the gentleman's amendment.
Further discussion on House Amendment 2. Gentleman from Boone.
To inquire of the amendment to the amendment.
This is gentleman from Cole Yield.
Yes.
Please proceed.
Thank you, gentlemen, for bringing this. And it came through committee yesterday, I believe, right?
Yes.
And I like it. I think it's a good idea. I mean, as elected officials, we shouldn't be intimidated or harassed. I think it's excellent. It's an excellent idea, so thank you for bringing it. But just to reiterate what's in it, so if somebody attempts to harass, intimidate, if they disseminate information to harass, intimidate, or to try to kill an elected official, for the purpose of killing an elected official, it's an A misdemeanor.
There's a difference there. Because, for the purpose to kill. And that would be a Class
If you disseminate information with the purpose to kill an elected official, it's an A misdemeanor.
That would be a D felony.
No, I think it's a D felony to influence.
Okay, you're correct on that. But again, if you do something, there are some other criminal codes out there that a prosecutor would have some discretion, in the normal criminal code. So those are not the things that, threatening to kill somebody can be its own, or conspiring with somebody to kill somebody can be a separate crime. So there are other major crimes, but it's just the public embarrassment and harassment, really what this one's going to cover mostly.
Sure, I understand that. But I was just clarifying that under this, the way it's written, if you intimidate, harass, if you disseminate information to intimidate, harass, or intent to cause serious bodily injury or to kill, it's an A misdemeanor. But if it's just to influence, it's a D felony. And the reason I bring that up is I like the idea. I mean, nobody wants to be intimidated or harassed or certainly have information released to attempt to kill any of us. My concern is just that it's bifurcated like that, because in the judicial piece earlier, they're together. So in the judicial piece that's earlier in the statute, it talks about intimidating or disseminating information with the intent to kill or to influence is all together and just one penalty. But this, it bifurcates it, one or the other. And my concern is there may be confusion, because if someone's charged with it, are you disseminating the information to intimidate or to influence? And I would argue they're kind of one and the same. So, because you could disseminate information to do both, right? Is it, if I'm in disseminating information to have you killed, I may also be doing that to influence you, right? We file a bill and someone starts disseminating information about us to do all of the above. And so I'd say that's my concern. And we talked about this in committee. I love the idea. I'm just wondering if it's the language issue for me, if that should all just be the same, either all a misdemeanor or all a felony, because I think there's going to be difficulties in interpretation of this.
There was the judicial section, though, on dissemination is similar to ours. And there was another reason to keep them apart, is because there is a certain people who don't want anything that they feel would prevent us exercising our First Amendment rights as it protects to making comments about our legislature and other elected officials. Right. But if you look back, dissemination is a separate category under ours.
Okay. I'm not sure I follow all of that. I think we could still follow the standard of the judicial officers, because people can disseminate. I mean, yes, we can do that. We can disseminate information. I'm just talking about those two caveats, because
Sure.
they're so similar. I mean, and how do you prove if someone's doing that to intimidate us or to influence us? I think it's kind of one and the same. I support it. I just wish if we could change the language to either making it all the same or just rolling those all together as we do with judicial officers.
I had that discussion, and it partially, we want the prosecutor to have some discretion, and that's where you come up with Class A misdemeanor versus Class
Yeah,
B.
and that could be very problematic because there's a lot of discretion there. So I support the concept. I would vote no just until we can maybe clean up the language, because I think it's problematic, but thank you.
Further discussion. Gentleman from St. Charles, Lovasco District.
Thank you, Mr. Speaker. To speak on the amendment to the amendment, please.
Please proceed.
Thank you, Mr. Speaker. So I get what we were going for here, and I think the thought is good. I actually initially read this over a few times and didn't really have a problem with it. And so I started digging a little bit deeper into the language. We just had a discussion about the concept of harassment or intimidation and what would meet those requirements. Of course, legally, they do have some definitions, and of course, you never really know what some of these things mean until you're in a court of law. But I would say a plain reading of this amendment could indicate that any activist group that encourages people or voters to contact their representative and then posts that person's information, they could be guilty of this under this section. A lot of us use our personal cell phone numbers on our campaign websites. It's not hard to find my personal information. I put a lot of it out to the public. If somebody decides they don't like one of my bills and they decide to share the information that I myself made available to the public, and then someone calls me on it, I don't think I should be able to run to a court and say, oh, this person's attempting to intimidate or harass me based on the information that I provided. There is no allotment for those type of scenarios in this language. Anytime that we're dealing with free speech issues and the ability of the public to petition their legislators or elected officials, we need to be real careful we get the language right, and I'm not convinced we've got that here, so I can't support this amendment. Thank you, Mr. Speaker.
Gentleman from St. Louis County, Windham District.
Thank you, Mr. Speaker. I'd like to inquire of the amendment handler, the amendment to the amendment handler.
Does the gentleman from Cole yield?
Yes.
Hey, gentlemen. So you spoke about how this amendment would protect public defenders?
They aren't elected, well, they're not an elected official.
They're
I
not?
apologize. They are not.
So do you think that there should be defined under the judicial officer definition?
Well, certainly, if they're not covered, I would not be opposed to adding them on my bill in judiciary yet, because that is one that I have seen some negative comments made about.
Yeah, I agree. I think it would be good if we're including all these other folks. What about municipal judges?
Our municipal judge is elected.
I'm sorry?
Our municipal judge is elected. And I think that the judges fall under the upper, they are judicial officer.
Well, is it defined? Because it says shall be a judge or commissioner of a state or federal court, arbitrator, special master, juvenile officer, deputy juvenile officer, state prosecutor or circuit attorney, state assistant prosecuting attorney or circuit attorney, juvenile court commissioner, state probation or parole officer, or referee.
I'm not seeing what line you're reading that from.
That is on the first page, line 23 through 26.
Oh, okay. Sorry about that. Yes.
Please. So
that is broader than elected officials, and that was what is in the law before. This is not something new on that section. Only Section 5 is new. That was already in the law. And our purpose of our amendment to this year was to make it so added some added language for the judges, personal information, and apply to elected officials.
Yeah, I get that. But municipal judges don't fall under the definition for judicial officer, so I don't think they would be included. At least in my county. So I get that in Cole that y'all elect y'all some municipal judges, but in St. Louis County we don't necessarily do that. I think that the speaker may even be a former municipal judge, and they're appointed by the mayors typically in St. Louis County.
I don't know how St. Louis does theirs. Ours is elected, so they would fall. But
so would you be willing to also add municipal judge under there?
Well, if there's time on this bill to do it, and if you have amendments now, but
Okay. And then my last question would be about the referee. Is there a judicial officer that's a referee? Is that an official term in the courts?
Well, we have commissioners.
Okay.
We do occasionally have appointed on domestic relation cases individuals who are we call them mediators. Yes.
Okay. Well, that's another good point. I didn't think about that. So I don't know why referee is in the definition for judicial officer. But I think another good suggestion there would be folks like the administrative hearing commissioners. I think that it may be some folks with big money that may be more intimidating than just the average activist that can post your phone number. So I think that, I'm not telling you what to do, but I think that may be something to think about.
And keep in mind here, we're talking about personal information. If I post my telephone number everywhere, it's no longer considered personal information. I made it public.
Okay. All right. Well, thank you, gentlemen. Thank you, Mr. Speaker.
Further discussion on House Amendment 2. Gentleman from Taney.
Thank you, Mr. Speaker. To speak on the amendment to the amendment.
Please proceed.
Mr. Speaker, I took a closer look at this amendment to the amendment because it speaks of elected officials. So I look at line 12 on page 2 where it states elected official or a family member of the elected official with the purpose to harass, intimidate, and so forth. I think harass and or intimidate are very subjective words. In the midst of a campaign, of course, an opponent could see something as being harassing or possible intimidating. I know when my wife sees some of the things that some of my opponents, even within this room, say about me on Twitter, she considers that harassment, and I say, no, honey, that's politics. But I am concerned that the verbiage found within this amendment to the amendment, particularly with harass or intimidate as referencing elected officials, could be somewhat confusing and subjective. Could someone, my campaigns, we participate in shock and awe. Okay, we go all out. We're going to win that office or the office that I'm currently holding for the next 6 years and then 8 years in the Senate. I could be said to be intimidating or harassing my opponent, or they could be doing the same to me when in actuality I am simply expressing my free speech rights to communicate with the general public. So I have some issues with this amendment to the amendment, and I think I'll be a no on it. Thank you.
Further discussion, lady from Boone.
Thank you, Mr. Speaker. To speak on the amendment to the amendment.
Please
or
proceed.
the amendment.
Please proceed.
Just one amendment, not amendment to the amendment. Thank you, Mr. Speaker. I have concerns that this might look like a special carve-out, because if you consider all elected officials in the state of Missouri, that is so many, from fire district, sewer district, school boards, you name it, top to bottom. And we sign up as an elected official to take the heat, to take the calls. We take the hits, whether it's Facebook, letters, emails, phone calls. That's our job. We signed up for. And yeah, I've had an assassination threat. Yeah, I've had my tires punctured. But we have laws on the books. We have laws for harassment, assault, everything else under the sun. And if this bill is moving through a committee on its own standalone feet, I think that's the correct avenue. I like the underlying bill from the representative from Jasper, and I want to keep it as clean as possible. And I love the amendment that cleans up language, but I think this isn't what this original underlying bill was designed for. And, you know, an elected official, how are you going to interpret harassment? You internet. People can find my phone number, my address, where I live. I think that's just part of the job. And so, you know, if you signed up to be an elected official, you're going to have to be ready to have some things slung at you. But we can't hide from our constituents, and we need to be able to be accessible. And we can't feel intimidated or afraid, because, you know, we got to do our job. And so I'm just not in favor of this amendment on this bill, but I have no problem with maybe it going through the process of a standalone bill. Thank you, Mr. Speaker.
Further discussion on House Amendment 2 to House Amendment 1. Seeing none, gentleman from Cole, you're recognized to close.
Keep in mind, this only talks about personal information. When you put your phone out there for public, it's no longer personal. But my wife's personal information, which you find someone, you publish it for the purpose of intent to intimidate her, harass her, I don't think it's anybody's right. Nor do they have the right to intimidate and try to pass personal information about my children. Nor should you expect that. We as elected officials step forward, but our whole families don't make that all commitment. Our grandchildren and children do not make that commitment. And this is a simple guideline, and as the judge said, it makes you wonder, you're willing to go here to bat, but I'm not willing to come up here and have my kids threatened, my kids intimidated, or make their life miserable. With that, I rest.
The gentleman from Cole has moved for the adoption of House Amendment 2 to House Amendment 1. All those in favor will signify by saying aye. And those opposed, no. And the ayes have it. You've adopted House Amendment 2 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Green.
Thank you, Mr. Speaker. I have an amendment to the amendment ending in .85H. It has been distributed, and I move for its adoption.
The gentleman from Green has moved for the adoption of House Amendment 3. Gentleman from Green.
Thank you, Mr. Speaker. This is just really a technical fix amendment to the underlying amendment. And what it does is it fixes some language that is included on page 4 of the underlying amendment at lines 38 through 40. And the language there discusses sexual contact with a minor, and has some language that suggests that if someone, you know, between the ages of 14 and 17 gives consent, then this conduct would be no longer criminal. But there's an issue with that, in that 14-year-olds and 15-year-olds and 16-year-olds aren't able to give consent under the law. So this just strikes those provisions to make sure that we are in in compliance with the current law and not running into a problem there. So with that, I'll take any questions.
Gentleman from Jasper.
Thank you, Mr. Speaker. To inquire of the gentleman from Green.
Does the gentleman from Green yield?
I do.
Please proceed.
Gentlemen, this is intended to preserve the piece of language that I referred to earlier that came from the other gentleman from Jasper, the Smith District, which I think was a very important piece of legislation. He worked on that for a long time, and we've had that around for about 3 years. And so this just makes it work within the context of the amendment.
Yeah, that is correct, sir.
All right. Thank you for the inquiry. I support your bill.
Further discussion on House Amendment 3. Seeing none, gentleman from Green, you're recognized to close.
Thank you, Mr. Speaker. I renew my motion.
The gentleman from Green has renewed the motion for the adoption of House Amendment 3 to House Amendment 1. All those in favor will signify by saying aye. Aye. And those opposed, no. And the ayes have it. You've adopted House Amendment 3 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Jackson. Sauls District.
Thank you, Mr. Speaker. I would like to briefly inquire of the gentleman from Jasper, please.
Does the bill handler yield?
I do.
All right.
Please proceed.
Thank you. Gentlemen, we were on the interim committee over this summer to work out some of these details and flesh them out. And I just want to start by saying I appreciate your willingness and your, it was a pleasure working with you on this. I think it's an important issue, and I appreciate you being open to addressing the problem. We had some language that we came together to submit out of that committee that ultimately did not make it through through crime prevention and public safety, and in particular was the diversion drug court language. And I suppose so. We had some communication. There were some concerns ultimately about that, and I believe that I have addressed those concerns, most of those concerns, not most of the concerns, but not one issue. And I guess ultimately with that, Mr. Speaker, I have an amendment. It ends in .52H. It's been distributed, and I move for its adoption.
The gentleman from Jackson has moved for the adoption of House Amendment 4. Gentleman from Jackson.
Yes, thank you, Mr. Speaker. So, I think it's ironic because today we got to hear from the judiciary, and if you were paying attention, as I was, they made Chief Justice made a point to talk about treatment courts. And I can tell you that I was a prior prosecutor, I was a prior public defender. I have had a lot of dealings with the treatment courts, and I'm very familiar with their successes. So what I have done and what we've been working on and worked on during committee was to make this a requirement to have drug courts. And some of the concerns that came out of committee, there was some concerns about what kind of cases and whether or not there would be judicial discretion and things of that nature, which I have addressed. I think we also, there's concerns about cost, which I think is also in here too. But anyway, that is ultimately, I will say this, that I think that treatment courts are, I don't have enough good things to say about them. I made this comment during committee, and I make it to everybody here on the House floor. You need to go watch a drug court graduation, because number one, it's to many of these people, it's like graduating from college or some major accomplishment, and it should be. It's a very, they take steps, and the reality of the situation is when a defendant graduates from drug court, there's a high likelihood that they're not going to come back. I think in Jackson County, I want to say it's in the neighborhood of 90%, which is good. And I think one important thing, and I guess this is what I would say to all of you today, is that a lot of this bill addresses after the fact. What are we going to do to crime after the fact? This is something that we do before the fact. It works, and that's why I've drafted this bill. Ultimately, I'm happy to discuss it with you all. I think it's a good bill. It's basically what it does is it requires treatment courts. There's a diversion track that if it fits under these guidelines, what would happen? It also makes it so that judges have discretion on a case-by-case basis, but ultimately, I think it's a great bill. I think it's a great amendment, and I would ask the body to support it. Thank you.
Further discussion on House Amendment 4. Gentleman from Cole.
To inquire the amendment maker.
Does the amendment maker yield?
Yes.
Please proceed.
Good afternoon, gentlemen.
Good afternoon.
I just got a question. I think we already have that. I think in my House Bill 547 that was passed my freshman year, it required that every circuit court in the entire state of Missouri have a treatment court by August 28th of 2021. Is that correct?
My understanding is that was a may. We did pass that, and ultimately...
No, it was a shall. It was
Okay.
mandate. That was the hard part about that bill, because we don't like the word mandate, and
Okay.
it was mandated that and so I gave them, at that time, 2 years to get it implemented. And there was only one circuit court that did not have it, so they had 2 years to find the funds. And it was actually a change because I wanted it to be the Veterans Court,
Right.
and so we changed it to Veteran Treatment Court so that every circuit court would have a treatment court.
Sure, and I don't, my understanding is there's still, because we looked it up in committee, there are still a couple counties that don't implement it, or maybe it's not updated. This does more than that, though.
Okay.
So this does talk about diversion, which is having practiced in multiple jurisdictions. Some jurisdictions have diversion courts, others don't. This implements a diversion process that I think is important. So it does more than just that, I guess, is the point I would say.
Well, I agree with you, and I've been to graduations, and there's not a dry eye in the place because these folks that have been able to go through there and complete the program, they got a second lease on life, and so I really support the idea of it. I just felt like we already had that. So.
Yeah, and again, like I said, it does more than just that. So I appreciate that. My recollection from that bill was that it was a may. If it's a shall, great. I think that, I think it was also veterans, but I mean, if it's a shall, great, but this also does more than just that, and I think I think it still should be implemented. Put it that way.
Okay, thank you, gentlemen.
Thank you, gentlemen.
Further discussion on House Amendment 4 to House Amendment 1. Gentleman from Jasper.
Thank you, Mr. Speaker. To inquire of the amendment to the amendment maker.
Does the gentleman from Jackson yield?
Yes.
Please proceed.
Thank you.
So we've talked a couple of times. I have experience with drug courts dating back to the 90s, and I concur with you. They are incredibly successful. What you're proposing is a little bit different in that this is actually a diversion program associated with the drug courts,
right,
wherein somebody never really gets into the judicial portion of it. They get charged, get diverted out, and they're sort of tabled, so to speak, until either they complete the program or fail the program. They fail, they go back.
Right.
If they do complete it, there is a carrot for them at the end of that they can. That's both predictable and dependable.
Yes. So, and I'm glad you brought that up. Yes. So, not every jurisdiction does the diversion part of this. Like I said, I've practiced in multiple jurisdictions. Some do, some don't. One of the problems is that for first-time felons, you got a drug case, and you're presented there, and often in some jurisdictions they require a guilty plea. The problem with that, and then that can come with an SIS, a suspended imposition of sentence. The problem with that is when you complete the program, your case is closed. It's not accessible to regular people. You can't go on CaseNet and find it. But for purposes of other things, it's a guilty to a felony plea, which does have consequences. This, like you mentioned, is the carrot part of this, where if you are a first-time felon with a drug nexus, not a dangerous, not a violent, not a sex offense, not a dangerous felony, you get the opportunity to have this maybe I'll go into a little background about diversion. So what happens in a case like that, if I'm the prosecuting attorney, I file the charge, I submit it, it goes out there, we get the defendant brought in, this is offered. If accepted, the defendant goes on for a period of time. I think of it like you're setting it for trial, but 2 years from now. And during that time, the defendant has the opportunity to engage in drug court, and if he or she graduates, case is dismissed, no guilty plea. That's what diversion is. And I think it's a very important part of it. I think it's to further that carrot, not just get your life in order, not just get off drugs, but also because you did everything you're supposed to, you don't have this felony conviction. And you look like I want to say something. So anyway, yeah, that's that.
So in a nutshell, the difference between the two is that in a non-diversion program, the plea comes before the drug court.
Correct.
And so whether the person graduates or not, they have a criminal conviction on their record. Whereas in a diversion program, the process is tabled. If they succeed, they're better citizens and they have no conviction. For some people, jail is simply not the answer.
Yep.
And this allows somebody to go become a responsible citizen without wearing that conviction for the rest of their life. Is that correct?
That's correct.
Yeah. Excellent. Thank you, Jim.
Thank you.
Further discussion on House Amendment 4. Gentleman from Pulaski.
Thank you, Mr. Speaker. To acquire of the amendment maker, the amendment to the amendment maker.
Does the gentleman from Jackson yield?
Yes.
Please proceed.
Good afternoon, gentlemen. I just want to reiterate some of our discussion in committee. So in committee, there were some concerns raised by some members. Some of them can't be here today, so I'm just going to do my best to try to muddle through what those concerns was.
Right.
So one is you say they shall be dismissed. And I note that the person going into the diversion program has not yet entered a plea of guilty.
Right.
But are there circumstances in which someone could have a new law offense? Maybe they violate terms of the agreement, and it's a change in situation, but they're somehow able to complete the treatment program. But maybe a plea of guilty would still be appropriate, or they're on probation at that point, right? Because they enter the program before they plead. So they're eligible before they plead. They go into the program. Maybe they pled to something in the meantime related to that. And then for whatever reason, they've gone on probation and violated it. Then if it's mandatory that it shall be dismissed, is that a mechanical problem? Like we'd have to set aside the plea, like we'd have to reopen evidence?
I don't think so, because at the end of the day, because the judge, you have the initial discretion, right? So if you're on the diversion court track, you're not pleading guilty. So that if something comes up, like as you mentioned, like what if he pleads guilty? Well, if that's the case, you haven't completed the program, right? Like completion of the treatment court program, in my experience, like so let's say hypothetically you got a criminal defendant who continues to violate, so that they need drug court, they're on drug court, they continue to violate the terms. And then typically what you would do is you'd kick them out of drug court. Like if that's what is going to happen, then you kick them out, and they either go through, which is also the second part here, they could still have an SIS probation, they could have an SES probation, they could do 120 days pursuant to 559115, they could take a plea of guilt, or they could do a term of years. So I guess if you're completing the program, then I would say no, because yes, you're not pleading guilty to the charge.
In my county, we started a drug court program in 2012. And in the early days, almost everybody who went to drug court was on felony probation. They had pled, maybe received an SIS for a drug charge, or it could have been quarterly charges, a burglary, something like that. Right. But there was somehow substance abuse involved. And they were on probation during their period of drug court treatment. And they may have completed the program, but maybe they had an issue, a new law offense. Maybe they didn't report to their probation officer, something like that. And in some cases, even some of those folks were revoked. They weren't taken off probation, but their sentence was imposed. They had an SES then. And if they couldn't functionally withdraw their plea or nolly it at that point because there was already a conviction. And so that's what I'm just trying to think through. And by the way, it's not necessarily criticism, but that's point one. Maybe they haven't pled yet, but while they're in the program, maybe they have pled and they're still in the program. Then how the shall dismiss charges?
Well, I'm glad you brought that up, because I think it's actually addressed in here. Give me 1 second to find it. The charges against the defendant for the criminal case requiring treatment by the treatment court shall be dismissed. So what you're talking about, you pick up some other charge. I mean, typically what happens, right. I mean, I guess if you picked up a new charge, depending on the level of the charge, it may be a situation where, if you have a new case and you're pleading to that case isn't dismissed because it's not a part of the case, right?
So that's another question I have. So it says any pending criminal cases that arise out of the situation for which you require treatment?
It says
any pending criminal something like that?
Pending charges against the defendant for the criminal case requiring treatment by the treatment court program shall be dismissed. So what
So-
that
Go ahead, please.
so what that is, it's the underlying charge, right? You're here because of a possession of heroin. You know, you're an addict and you need help. That's why you're here. You complete the program. We dismiss the charge. Everything is, you know, and hopefully you're in the 93% that don't ever come back.
But if it's independent criminal charges, so there'd be a substance abuse or drug-related offense, and that would make them eligible for drug court. And then there may be a violent offense that happened at the same time, or there may be a subsequent violent offense. Would those cases also have to be dismissed, or no, under this language?
No, because at the end of the day, those are separate cases. So, and as it's outlined, you don't get, you know, they're dangerous felonies. You don't include that, and the judge has the discretion on a case-by-case basis. So, I don't anticipate that being really quite a problem. You know, like at the end of the day, it's this underlying charge. Now, it doesn't necessarily have to be a drug case. Like, let's say hypothetically somebody got, you know, they're addicted to drugs, as one is who's an addict, and you go out and you do, let's say you go do some property damage, right? So you do, you know, they look at the case, they're like, well, you know, you qualify for drug court, it seems like you're a good candidate, we'll put you in this program. Then that can be theoretically out of that. Now, typically, like I mentioned before, restitution is considered, we've always done that, a restitution is part of a case. So again, part of this is going to be that you complete your drug court, you pay your restitution, and we go that way.
And again, I'm trying to reiterate just some of the concerns that were brought up.
Right.
I think the way that concern was framed was that, let's say you could have a first-degree assault, and you could have a possession of controlled substance. And then maybe, for whatever reason, we held off on adjudicating or processing the assault charge, or whatever correlated charge. Maybe there's a crime involving restitution. But the person, we think it's appropriate on a case-by-case basis, as your language says, to go through this drug court program. And so the concern was, it says any independent criminal charges arising out of the case. Well, the case could have multiple charges on it when it's filed, and one of them could be a drug charge. So I think that was the concern that would obligate the prosecutor to dismiss those corollary charges.
And I guess, so I believe that's covered under the language. And what I mean by that is, number one, like it says down here, first-time felony offenders, no dangerous felonies. You got an assault one like that, like you're talking about, you don't qualify. It's determined on a case-by-case basis. Now, if you're, let's say, you know, I'm prosecutor, and I'm looking at the charge, and I go, you know what, I don't think I have enough here on the assault. I'm going to just put this over here. You have, number one, you got a statute of limitations issue that you may run across, but you'd still have, you complete the program, and then you're going to wait 2 years. You're going to let them graduate from drug court, and then file a felony assault on them. I mean, I don't think that's a realistic situation, right? Like if you have the felony assault, you charge it. If you don't, because you don't have the evidence, then you don't have the evidence. But the situation you're talking about, I just don't necessarily see that, because ultimately, if I'm making the decision, first-time felony offenders, no dangerous felonies, I wouldn't put them in the program. They don't qualify.
I really appreciate that, and I appreciate your efforts to try to make sure we get ahead of the crime problem, addressing some of the underlying issues, right, such as substance abuse. I thought it would be helpful, though, to reiterate some of the concerns the committee had.
I understand.
And I'll leave it there. Thank you, Representative.
Thank you.
Further discussion on House Amendment 4 to House Amendment 1. Oh, gentleman from Taney.
Thank you, Mr. Speaker. To inquire of the amendment to the amendment maker.
Does the gentleman from Jackson yield?
I do.
Please proceed.
Thank you.
Thank you, Mr. Speaker. Well, here we are again.
Yep.
We had a great discussion in committee as we were vetting House Bill 301, particularly with this amendment to the amendment that you're attempting to add. Have you made changes to it?
Yes.
And so I'm noticing something that we discussed in committee concerning the word shall and what's in current statute, which is may. Now, words do have meaning. Shall is a mandate, and that's what's currently in this amendment to the amendment, whereas may allows for judge's discretion, which we currently have in statute. Why the return to shall when we already discussed this? It was voted down in committee, and here it is again.
Well, like I said, there were several issues that were outlined, and I believe I covered all of them with exception of this. The reason for that is, number one, a may is useless. I may do it, you may do it now, right? We as a body voted out several years ago the Veterans Treatment Court, as indicated. I thought it was a may, apparently it was a shall. I think this is, ultimately, that was the only thing I didn't change, and the reason I didn't change it is because basically it does nothing. If I put may, what are we doing? Right? We're not doing anything different. It's useless at that point. A shall requires that you go through it. It also does add, there were concerns about various things, and I did put those in here. I did put those in here, and I feel like I've addressed the other concerns with exception to that. The only reason I didn't address that one is, again, it's useless. I could put may on there. It's not.
I think the word may is currently in statute and allows for discretion within a jurisdiction. Right. Do all jurisdictions need a drug court? Is that something necessary everywhere in the state of Missouri? And I would suggest it's not. Now, in some areas, it's very important and it's appropriate, and as you presented in committee, it actually works. But we need to allow the judge's discretion, and that's why may is currently in statute, and we're not looking for a mandate as shall. You have to do this. Right. That's tie in the hands of the prosecutors, the judges, and so forth. So I think there is a huge difference between shall and may.
Well, I would agree with you that there is a difference between shall and may, but that being said, if you're asking, do all places need drug courts? Yes, all places do need drug courts, because at the end of the day, if you're truly trying to impact crime, I think if you're really trying to impact crime, then, and I come before you and I say, listen, I've got a program where 97% of the people, or 93% of the people who graduate do not commit new crimes. Is that not something that you would want for your community? Because it's not just, as I said in the committee, it's not just the drug crime, right? The person who's addicted to drugs, who's out there looking for money to get drugs, commits assaults, they commit burglaries, they steal. They do all kinds of things that ultimately bring them here. If I've fixed that problem and that person no longer has that addiction, then they no longer are breaking into cars. They're no longer breaking into houses. And it's just, having been someone who's worked in this for 10 years as a prosecutor and a public defender, I don't think there's anything that we can do as a body to impact crime that we would willingly do than this.
Okay, I thank you for the inquiry. Mr. Speaker, to speak on the amendment to the amendment. Thank you, Mr. Speaker. The purpose of committees, especially this year, is to vet bills. And I think that's what we did in the Crime Prevention and Public Policy Committee. I'm a little bit dismayed that we're seeing things that were thoroughly vetted, thoroughly discussed for hour upon hour, even simple word differences like shall and may, as we went over House Bill 301 line by line. Some of these snakes are rearing their head again in this body in an attempt to overrule what we discussed in the committee and the decisions that we made after thoroughly vetting the bill. Mr. Speaker, I am concerned that House Bill 301 is going back to what we stopped in the committee last week. Thank you, Mr. Speaker.
Any further discussion on House Amendment 4 to House Amendment 1? Gentleman from St. Louis City.
To inquire of the amendment maker.
Proceed.
Yep. Thank you.
Good morning, gentlemen. Evening, gentlemen. How are you doing?
Doing all right. How are you?
All right. We discussed this in committee. That is true. However, you did bring out the fact that it does not include dangerous felonies, correct?
Correct.
Sexual offenses?
Correct.
Do you believe that drugs is a problem in every jurisdiction in the state of Missouri?
I think anybody who's telling you otherwise is not being either honest with themselves or don't truly know the situation. Drugs are a problem in rural Missouri just as much as they are in urban areas and suburbs.
Thank you. I agree with you. I have worked with diversion programs in the city of St. Louis, and I honestly believe they do work, and it stops recidivism rates. So I agree with your amendment, and I will support it. Thank you, Mr. Speaker.
Thank you.
Further discussion. Lady from St. Louis.
Thank you, Mr. Speaker. To inquire of the amendment to the amendment maker.
This is gentleman from Jackson Yield.
Yes.
Please proceed.
Hello, gentlemen. Hi. Okay, so we serve on crime prevention and public safety together.
Yes.
And I know I support your amendment.
Thank you.
One of the reasons why I support your amendment is because it would reduce babies being born and exposed prenatally to drugs and alcohol. And I'm big on that. It also reduces recidivism. It also reduces crime and children going into foster care. I get all of that. But I just wanted to point out, because I looked up, and I don't know if you remember when I brought this up,
right,
the Missouri treatment courts. And I agree with you that the need for drug treatment courts, it should be a need all across the state of Missouri. And it should be placed in every jurisdiction, in my opinion. And I agree with you. And so do you remember when I brought up the stats based off of the Treatment Courts Coordinating Commission that was established in 2018? And I have all of the counties that currently do not have adult treatment courts.
Yes, and I guess that's one other thing. Apparently, we passed the bill a couple years ago. That's 2018, so maybe that's not reflected. But continue. Yeah.
Well, the website is updated, and they updated in January of 2023. Okay. And the current counties that do not have adult treatment courts, because I know you and another gentleman went back and forth about a bill that was passed, and possibly that all drug treatment courts or all jurisdictions have drug treatment courts, when in fact they do not. And this is what is currently on the website right now by something that we put in statute back in 2018 before I even got here. And so current counties like Clinton, Curl, Howard, Morgan, Polk, Dallas, Hickory, Texas, Marys, Monroe, Rowless, and Marion, and other counties currently do not have adult treatment courts. And so I just wanted to reiterate that to you. We talked about it on the committee, and let that be known that that is a statute. That's something that's in statute, that we have this commission, but every county does not have drug treatment courts.
And I appreciate you doing that. There is one other thing that I just thought about that was brought up from the gentleman from Taney, that the purpose of a committee, the one that we were on, the one that I was on prior to with the gentleman from Jasper and several other members, is to vet and find common ground solutions, work through things. I feel like we did that. The bill itself has a couple of there were multiple issues that were brought up. I did my best to change everything with exception of one, and to suggest that perhaps I was I don't know. I guess the snake comment kind of got to me, but I don't. Number one, it's drug treatment courts. That's it. This is an effort to try to make it so that these highly successful courts are implemented throughout our state. And what I said before, dealing with doing this beforehand, because again, we're doing stuff after the fact. I submit to all of you, I want you to think about this right now, and that is, if we made every crime punishable by 30 years, would we impact crime? And I think some of you are going to say that, but at the end of the day, there's crime is out there. There's ranges of punishment. People are going to do things because of various reasons. But if we address the underlying problem, we get to the problem at hand, such as this, I think we actually really do impact crime. Again, check with your treatment courts. 93% are successful. Nobody comes back who graduates, 93% of them. So I think it's a great plan, great option. Thank you.
I do too, and just to put this on the record, we literally just passed an amendment that, yes, it was heard in committee before you started your amendment. We just heard an amendment that, yes, it was heard in committee just yesterday, but it had not been voted on. So in my opinion, it had not been properly vetted in committee, and so we passed that amendment, and so I believe that we can truly pass your amendment as well. So I would urge the body to support your amendment. Thank you.
Lady from St. Louis City.
Thank you, Mr. Speaker. To briefly inquire of the amendment to the amendment maker.
Does the gentleman from Jackson yield?
Yes, thank you.
Please proceed.
Hey, gentlemen, I'm just going to make this quick because I know we've got a large amount of topics to have a discussion about. The amendment that you're trying to amend, does it have all of the changes in there that we did in committee when it was passed out?
I feel like it had, so you're talking about specifically, does my amendment reflect the changes that the committee?
No, not your amendment, but the amendment in which you are amending. Does that amendment have the changes, or is it undoing the changes of what we passed out of committee?
It's undoing some of the changes that we passed out of committee.
So to say that we're going against the will, or you're going against the will of the committee, would not be correct.
Correct, because that's a good point.
I mean, it just makes sense when we've had a long conversation, almost a 3-hour conversation about what we wanted as a committee, and then yet now we have an amendment that's overturning that, but your amendment didn't necessarily get voted down. You just needed to change that one piece, and that's what you did. I don't think there's anything snakish about that, gentlemen.
Yeah, I don't either, and I think that's, I'm not really going to comment on that other than to say that I feel like I took into consideration the concerns. I feel like I tried to address most of those. The main hang-up was the may and the shall. I don't know how else to say it other than the fact that it does nothing. If I put may in there, it does nothing. You may do it now.
Right,
okay,
it just takes it away. It doesn't give any teeth to actually making it work, because you have a fentanyl problem in rural Missouri as well, where you have a lot of people who are overdosing, etc. This will now give them an opportunity for those people who survive from those overdoses to be able to turn over a new lease or have a new lease on life, as someone already stated earlier.
Correct.
Okay, just making sure.
Thank you.
Thank you, Mr. Speaker.
Further discussion on House Amendment 4 to House Amendment 1. Gentleman from St. Charles County.
Thank you, Mr. Speaker. To inquire from the amendment to the amendment maker.
Does the gentleman from Jackson yield?
Yes.
Please proceed.
Thanks. Hi.
Good afternoon.
Good afternoon.
As you know, we were in committee on this together, and I have some consternation with some of the things in here. Let's talk first. I am lucky to have a drug treatment court in my county. It works well. My judges love it. So I'm not against the drug treatment courts. However, when we start forcing courts to have this in there, that where they may not be needed or they cannot afford them, I have some issues with. So the shalls definitely count this out for me. But I want to talk more about the all. Would you consider alcohol to be a drug and a drug that can be abused and referred to these courts?
No, because you have separate the statutes outline for separate DWI courts. If you want to do, that's actually why I put drug treatment in here. Because it's
so you're saying though that abuse of alcohol would not get you any way into this?
No, the statutes outline specific DWI, DUI courts, and those are outlined in statute. If you want to have one, you do that. Drug is different.
Well, that was where I was going, but still, even if it's not, it has to do with driving at all. Would alcohol will intend you to get you into this court?
Again, I would say no because of that. But you mentioned one other thing that I wanted to talk about. Let's see. What was your first concern?
The shalls.
The shalls. Okay. I guess here's my comment. This bill has a lot of shalls in it as it is, right? We're going to make it so that we shall go into the city of St. Louis. That's what I know that's kind of the underlying thing here. We're going to go in there. And we're going to implement something that's going to usurp a prosecutor's discretion. We shall do that, right? We're going to do that.
Yes, sir.
So I guess I'll push back on that, because at the end of the day, this is something that is going to impact crime. You said drug courts are great.
Yes.
Drug courts are great. They should be in every community. And if you're really trying to hit a crime, if you're really trying to get at it, then why not implement a policy that has a 93% success rate?
Well, as I said before, okay, the courts, it should be up to the court's decision, the community's decision in which they serve. It
still is. The judge does have discretion on a case-by-case basis. So. It's in the language.
Okay, well, I can't be on it for the shalls, and of course the all, you kind of cut me off as to where I was going was, so you're saying alcohol would not be a reason you would be referred to this court?
I would say that alcohol, there are specific DUI courts in statute. I think that if you want to have a DUI court, you go ahead and do that. They're not.
So you say there's no opportunity that a judge may place you into this court for driving while intoxicated and possibly killing somebody and creating an involuntary manslaughter charge, which is not a violent crime, by the way. It's a crime of negligence.
I think that you, again, and I think if you read the whole thing, right, this part here, if the provisions of this don't apply or not utilized, you can use this, which if you want to do that, you can do that. Okay. You can still have it. You can still have something else out here where you get an SIS. You could do a drug court, or you could do DUI under that under a treatment part of that.
Thank you for the inquiry.
Thank you,
Mr. Speaker, to speak on the bill.
Please proceed.
Mr. Speaker, there's two shells in here I don't agree with, and definitely the all that I do not agree with. With this language in the amendment, I cannot support it. Thank you.
Further discussion on House Amendment 4 to House Amendment 1. Lady from St. Louis, Jackson, I'm sorry. Sort of North Jackson.
Thank you, Mr. Speaker. To inquire of the amendment to the amendment maker.
Does the gentleman from Jackson yield?
Oh, sorry, yes. Yes, thank you.
Good afternoon, Representative. How are you?
Afternoon. Doing all right. How are you doing?
So I want to clear the mays and the shalls of it all.
Right.
And so my understanding of this is that the may is already in statute in which the prosecutor may send the plaintiff to drug court. Is that correct?
Correct.
And then we have a if-then situation. If the prosecutor chooses to send the plaintiff to drug court, then they shall. Is that correct?
It would fall under, so if you qualify, and again, it goes, a defendant has, or a judge, it's a case-by-case basis, then yes.
Okay, that's all I got. Thank you.
Thanks.
Further discussion on House Amendment 4 to House Amendment 1. Seeing none, gentleman from Jackson, you're recognized to close.
Yes, thank you, Mr. Speaker. So first, I'd like to, if I could have 5 minutes standing, I'd like to request a roll call.
You will have your roll call vote, gentlemen.
Thank you. So I want to, I think some of the criticism on this is not fairly directed, and I'll put that because I think at the end of the day, these concerns have been addressed. Number one, this is a legislative body. We all get to make our decisions. Nothing is stuck to a specific committee. We, as a legislative body, are offering amendments right now to this bill that maybe necessarily didn't have the votes in committee or something to that effect. This is, if you can do one thing today, this is the way to make it so that you can impact crime. As someone who's done this, as someone who's seen this, these courts are highly successful. Everything we're doing here today is after the fact, with exception of something like this, which would affect crime before the fact. And if we're really trying to hit at the problem, this is what we do. And I just think that, this is a very important thing. I think I would ask that the body support it. Thank you.
The gentleman from Jackson has renewed his motion for the adoption of House Amendment 4 to House Amendment 1. All those in favor will vote aye. Those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 47 yea, 93 nay, and 1 present, you have failed to adopt House Amendment 4 to House Amendment 1. Gentlemen from further discussion on House Amendment 1. Gentleman from Newton.
Thank you, Mr. Speaker. If I may pose on you to make an amendment to the amendment ending in .86H. I move for its adoption.
Gentleman from Newton has moved for the adoption of House Amendment 5 to House Amendment 1. Gentleman from Newton.
Thank you, Mr. Speaker. This is just a quick fix that I think needs to be put into the statute. And I did speak with the bill sponsor on this, even though this was kind of a quick thing. But basically what this amendment does is in our statute currently, there are certain firearms that are defined, that we defer to the federal government as to the definition of those firearms. So what this bill, or what this amendment does is just remove that and say that the Missouri legislature should define the firearms that we put in our statute, and that way we don't have to defer to the federal government. We don't have to defer to maybe an arbitrary change that could come down the pike in the future. So I think it's something that the Missouri legislature should define. And with that, if there are no further questions, I close.
Further discussion on House Amendment 5 to House Amendment 1. Gentleman from St. Louis County.
St. Louis City, Mr. Speaker.
Okay.
To inquire of the amendment maker.
Does the gentleman from Newton yield, and do you have a clear path?
Yes, I do.
Please proceed.
Thank you. So I think I support this fix. It's something I brought up when SAPA was being passed a couple years ago. I do think that's a problem that needs to be fixed. I appreciate you doing it. On the page before, there's something else, though, that I don't think you mentioned.
Page before.
The page before the part that you described in your opening.
That's the only change I see, gentlemen.
The change to the definition of rifle?
That wouldn't be a change. It would just be deferring to the federal.
You take out the language that says or adapted.
Oh, yes. I'm sorry. You're right. I'm trying to find that here. On a rifle, yes. Yeah, there is a quick fix there as well, where it says or adapted. That has been struck out.
Seems like something worth noting. Can you explain why you did that?
So I think we're just going with the cut and dry definition of what rifle is. Any firearm designed to be fired from the shoulder and to use the energy of the explosive in a fixed metallic cartridge to fire a projectile through a rifled bore by a single function of the trigger.
So, or adapted would make it that under our current definition, if it wasn't a gun that was designed to operate as a firearm, but has been adapted with added parts to then operate under that same definition, isn't that the point of adapt or adapted being in there?
I'm not sure what you're getting at, though, with...
If it wasn't designed as, but is operating as because of adaptations made to the firearm...
But that doesn't change what it actually is and how it actually functions.
Doesn't it? If it's adapted to do all of the things that meet the definition of a rifle, how is that not a rifle?
So adapting that to how it functions... In what way?
If once, you know what, I don't know a whole lot about rifles. I won't pretend to be an expert. But I know that that language was put in there for a reason.
But it doesn't change anything,
it does.
Any function of how a rifle would function, though.
It does. If a firearm was not designed as a rifle, but the person who owns it adapts it.
So give me an example of how that would work.
I don't know. That's my point. That's why I'm asking you why this needs to be taken out. Why is this language being taken out?
Because it doesn't change anything as far as
then
the
why does it need to be taken
rifle.
out?
I like downsizing government, gentlemen.
Mr. Speaker, to speak on the bill.
Please proceed.
I think you should all in this chamber take note of what's happening here. Feels like there's a little dishonesty happening. There's some language that is in a definition here that is being removed. That language has a reason. And that reason seems to me to be, as somebody who is not an expert on the mechanics of firearms, to make sure that a firearm that is purchased as one type of firearm, but with accessories and other things that they do aftermarket, they adapt it to function in a different way that now then meets the definition of a rifle, that's a rifle. The only thing that taking out or adapted can do is mean that some guns that act as a rifle aren't treated as a rifle. Doesn't that defeat the whole point of us treating rifles differently under the law? Now, I understand that the gentleman thinks that it's trivial. If it were trivial, why is he doing it? And why wasn't it brought up in the introduction when all we heard about was something that I think we can all widely agree is a helpful little tiny fix? I'd support that fix. But I don't think I can support this amendment. Thank you, Mr. Speaker.
Further discussion. Gentleman from Pike.
To speak from a microphone other than my own.
Please proceed.
Okay. I believe the body just heard the gentleman previous to me admit on 2 occasions he is not to be considered an expert or know much at all about rifles. I, however, should be considered an expert. I know a lot about rifles. It's a great amendment to the amendment, and I encourage the body to approve it. Thank you, Mr. Speaker.
Further discussion on House Amendment 5 to House Amendment 1. Seeing none, gentleman from Newton, you're recognized to close.
Oh, thank you, Mr. Speaker.
Oh, wait, hold on. I'm sorry. I got a gentleman over here. I didn't see him here. Gentleman from St. Louis County.
Thank you, Mr. Speaker. To inquire the gentleman from Newton County.
Does the gentleman from Newton yield?
Absolutely.
Please proceed.
Afternoon, gentlemen.
Good afternoon, gentlemen. So going back, I just want to clarify what Representative from the Meredith District was talking about, and just want to have an honest conversation about it. So we know an AR-15 pistol, right? You invited me to that event?
Yes.
And I learned a whole lot there.
I expect
and
you
they
did.
held up this gun that was about this long and called it a pistol, didn't they?
Yep.
Yeah, they did. Okay.
They didn't call it that. The law does.
Right, that's right. And what is the ATF trying to do right now regarding those pistols and the change that was talked about at that meeting that we had there in Newton County?
If I recollect what the ATF is doing, I mean, I try to do, try to keep up with what they're doing. But I think there has been a change in some promulgation of a rule. It's very arbitrary regarding pistol braces, I believe.
Right. So they developed this equipment for disabled veterans, correct?
Yes.
An arm brace.
Yes.
So a disabled veteran could strap on an AR-15 onto their arm if they were disabled and still shoot an AR-15. Is that correct?
That's one use, yes.
Right. But that's what it was developed for, correct?
That's what some say, yes.
That's what was explained to us at the meeting from the professionals, right?
Sure.
Right. And now people are using what is supposed to be used as an arm brace for disabled folks as a stock, which then turns it into a rifle, correct?
I don't believe that's actually the case.
Is that what the ATF is saying?
Well, the ATF may say that, but that's what I'm challenging. I'm saying that I don't know what makes this different, 4 inches different from putting it to your shoulder, doesn't change it, the actual definition of what a rifle is.
Because you are taking a pistol and you are putting a piece of equipment on it to change how that pistol functions
to make
into
it
a
more
rifle style, tactical style assault rifle.
Well, no, that's not correct. But it does make it more safe, yes.
Excuse me, sir. When you take an arm brace and you no longer use it as an arm brace, but you then extend that arm brace and it touches right here on the front of your chest,
yes.
It is then being used as a stock. Is that correct?
A safe stock, yes.
Right. And that's what the ATF is saying they have a problem with.
Yeah, and please explain to me why.
Well, because it's no longer being used as a pistol.
And that means what when it comes to
that means
the
that
function of the gun?
That means going back to what the representative from the Meredith District said.
Does that make it easier to conceal?
We're not talking about concealment. We're talking about the effectiveness of it. We're talking about a tactical style rifle.
Effectiveness of it.
That's right.
So
the amount of carnage it can create.
No, that's not the case at all, gentlemen, when it comes to the actual use of that piece of plastic that can go on the end of that pistol.
I think what the gentleman from the Meredith District was saying is exactly what I'm talking about, and the ATF has a problem with it, and people
Well, just
are
because the ATF has a problem with it doesn't mean that it's a correct definition.
Right, but you're being disingenuous.
No, I'm
right?
not.
And
I'm
we're
being
talking
honest.
we're talking about the spirit of what this equipment was made for, and people are misusing it, which is why things need to change.
So you realize that the ATF has went back and forth on that definition. So just recently, they said, oh, it's okay to put it to your shoulder. You realize that, right?
No, the ATF is saying that you cannot put it to your shoulder.
Again, they are now, but they have already made the determination at one point that you could
But
put
their
it to your shoulder.
determination now is that you can't.
And what changed, gentlemen?
Ask the ATF.
I do, and they can't give me a good reason.
What I'm saying
it's
is
arbitrary.
What I'm saying is, let's just be genuine about the spirit of your bill. That's all I'm asking, and I think the gentleman from the
spirit
Meredith
of
District.
my bill
excuse me,
says-
sir. Excuse me, sir. I think the gentleman from the Meredith District made a very good point, and I appreciate you inviting me to that. I learned a lot. We had a good time, but let's be honest about these bills. It has people's lives at stake there. So thank you very much, sir. I appreciate the inquiry. Thank you, Mr. Speaker.
Further discussion on House Amendment 5 to House Amendment 1. Gentleman from St. Louis.
Thank you, Mr. Speaker. To quickly inquire of the amendment maker.
Does the amendment maker yield?
Absolutely.
Please proceed.
I appreciate that back and forth, and this is on a slightly different. I just want to follow up on exactly what you say. So when I'm out with a pistol, I'm good from 28 feet, 30 feet, 45 feet. You let me put it against my shoulder, my distance increases to 50, 60, 70 yards. So when I think in the exchange, isn't it true? And he said, I don't know why.
So your accuracy increases.
Your
you're saying.
accuracy, and that is why people.
Which makes it
would
safer.
Well, it makes it more deadly. It makes it more deadly. There's no doubt about it.
It makes it safer.
It makes it more deadly. That's clearly, that if we're in a pistol fight, I got a half a chance of you not hitting me. With a rifle adaptation.
So let me ask you this. Can you shoulder an AR pistol without the piece of plastic?
Not well.
Yes, you can.
Not well.
Oh, yes, you can.
Not well.
With a buffer
it adds-
tube, you can put it right into your shoulder and shoulder that just as well as you can with a piece of plastic on it and just as safely.
It adds a
So what's the
little bit
purpose?
for greater aim and greater distance. I mean, that is the purpose. So when you were just having the exchange and you said, well, I don't know why it matters. It matters because it increases the lethalness of the weapon. So I appreciate the inquiry. Thank you, Mr. Speaker.
Further discussion. Gentleman from St. Louis County.
Thank you, Mr. Speaker. I'd like to inquire of the gentleman.
Gentleman from Jasper Yield.
Newton.
I'm sorry.
Yes.
Please proceed.
You said that it makes guns safer
Yes.
if you can shoot from further away?
Yeah. If you can shoot accurately with the gun, it makes it safer. That way you're not spraying bullets everywhere in places where they shouldn't be intended to go.
Okay. Have you ever thought about that from a target's perspective? Somebody that's having a gun aimed at them?
So, gentlemen, you're way off topic here.
Are you going to answer the question?
It has nothing to do with my amendment.
It sounds like you're talking about this from the hunter's perspective. I want you to think about it from the
No, I'm
huntee's perspective.
I'm talking
from the
about
lion's
this from the
perspective.
piece of
Because
equipment.
hold on,
and
gentlemen,
that
let me talk.
perspective.
Let me talk. You're not going to answer the question.
I'm listening.
All right. So if you don't think about it from the person that's being aimed at, it sounds like the hunter is telling the story for the hunted. And if that's what you turn this building into, then it doesn't fall into this bill at all because we're supposed to be talking about victims.
No, this
but it
is
looks
public
like you're helping
safety,
people being
gentlemen.
victimized.
Public safety is what we're talking about.
So have you ever thought about this from the person having the gun aimed at them?
My amendment has to do with the function of a rifle
Doesn't sound like
and the
you're gonna answer the
definition of
question.
it.
Okay.
And saying that we, as a body, should make those definitions, not the federal government. That's all my amendment does, gentlemen.
Okay. Do you think that this amendment would make the folks that were in St. Louis City at their school that was a victim of a mass shooting, do you think it makes them more safe?
Gentlemen, I try to
Yes or
make
no?
I try to make laws.
Thank you, gentlemen. Thank you, Mr. Speaker.
Further discussion on House Amendment 5 to House Amendment 1. Gentleman from St. Louis County.
Thank you, Mr. Speaker. To inquire of the gentleman from Newton.
This is a gentleman from Newton. Yield.
Sure.
Please proceed.
Afternoon. Evening.
Sir, we've heard several people in this body speak about not knowing about firearms and yet speaking about firearms. So
I've heard that several times.
I am a firearms instructor. also an armor. So, first of all, let me ask you a question. Does the ATF make laws?
They shouldn't, but I think they have.
Well, they've attempted to.
Yeah.
That's a good answer. When we're talking about accuracy, and the gentleman, I'm sorry, I don't know where he's from, spoke about accuracy, and he said deadly. We said safer. Let me talk to you all about accuracy, why this is so important. As a firearms instructor, accuracy means safe. You shoot what you're aiming at. You take your time. You never point a weapon at something that you don't intend to shoot, whether that be a target, whether that be an animal gaming, or whether that is a person that's attacking you or your family. And the reason that is so important is because a pistol is inherently less accurate than a rifle. And being able to shoulder that weapon allows you to hit what you're aiming at instead of the people that are standing behind that person, next to that person, who are not the intended target. We need to be very careful when we start talking about things that we have no idea or any background talking about. And that's my point, sir.
Thank you, gentlemen.
Further discussion on House Amendment 5 to House Amendment 1. Seeing none, gentleman from Newton, you're recognized to close.
I close.
Gentleman from Newton has renewed his motion for the adoption of House Amendment 5 to House Amendment 1. All those in favor will signify by saying aye. Aye. And those opposed, no. And the ayes have it. You've adopted House Amendment 5 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Jackson Sharp District.
Thank you, Mr. Speaker. I have an amendment ending in .05H. It's been distributed, and I move for its adoption.
Gentlemen, is this an amendment to the amendment, or is this an underlying amendment to the underlying bill?
To the underlying bill.
Okay, we are on Amendment 1 to the underlying bill. Further discussion on House Amendment 1. Lady from St. Louis City, Behringer District.
Thank you, Mr. Speaker. May I inquire of the bill handler?
Does the gentleman from Jasper yield?
I do.
Please proceed.
Good evening, gentlemen.
Good afternoon.
Aren't you glad that we have this nice soft carpeting since you've had to stand there how long now?
I've mentioned to a couple people next time I'm bringing my slippers.
I want to thank you because you have a fabulous demeanor and you were perfect to have been chosen to do this task force.
I appreciate that. Thank you.
And I appreciate what you said about the juveniles and the firearms because you said it in the demeanor that makes people listen and understand and comprehend. So I wanted to make sure that I inquired of you that when we came up as a task force and we met last year, we were not an official committee, so we came up here on our own time, on our own dime.
That's correct. We were a working group. It was at our expense.
Okay. And the other thing was the very first time we met up here, I was a little confused why I was on the committee because I said, oh my God, 3 lawyers, 2 former law enforcement officers, what am I doing here?
Well, we had to have somebody who made sense.
So I am one of those people, and if you've not had a chance to serve with me, you've learned that I'm extremely diligent. I do my homework, and it's not about me. It's about what have I been asked to do, and that is what I did. And each of us were offered a piece of legislation to put in this. Of the 6 of us, we each had something that went into this bill, correct?
Yes.
Okay. And I think that's the important part, because probably by word of mouth, everyone in here probably knows what piece was mine. The juvenile firearms.
Yes.
All right. Thank you. Mr. Speaker, I have an amendment to the amendment ending in 73H. It has been distributed, and I move for its adoption.
The lady from St. Louis City has moved for the adoption of House Amendment 6 to House Amendment 1. Further discussion, lady from St. Louis City.
Thank you, Mr. Speaker. I just want to let everyone in here know that this is a very, I know you hear this, and you're going to hear it, and if you're a freshman, you're going to hear it for a long time. It actually is a simple amendment. And the reason I say it's simple is because I represent the city of St. Louis. Some of you have probably been in my district, Ted Drew's, Candy Cane Lane, and I have a very close working relationship with my police officers. And so when I was tasked with this, I was excited because I said, what can I do? What can I do? Because we do know a year ago, the crime in the city of St. Louis was murders. Murders, 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 murders. And then the tide started to change. And when I met with the judicial branch, when I met with the police officers, it had changed to, what is going on now? We have 14-year-olds walking down the middle of the street in the city of St. Louis carrying AR-15s. What has happened to us? So I did do my work, and I didn't want to let this be known. I really didn't, because we all found out what happened when they did it on YouTube, how to steal a Kia. 6,000 Kias in the city of St. Louis have been stolen this year, and now if you have a Kia, the insurance companies have dropped you in the city of St. Louis. So I said, who's doing all this? 14-year-olds, 12-year-olds. These are children. These are children. And they have firearms. And so now they have been emboldened and they're walking around with them. And until they actually brandish them and brandish them with intent, our police officers' hands are handcuffed. They are tied. And in the city of St. Louis, and I'm sorry if you have it differently where you are, you always have to say, if you're a police officer, if I make the wrong move, am I ruining my career? And that's where we're at. So I did this amendment because they said to me, the police officer said to me, if you do anything for us, make it so we could actually stop these children with these guns. And the reason they can carry the guns, firearms, is because you used to be able to do it with a CCW. When we got away from the CCW, there was no way to set a minimum age requirement. Now, be very clear, Missouri Department of Conservation, public land, they do have a requirement. You're allowed to hunt on any of their land as long as you take their 4-hour class. So they have at least that. But now the cat's out of the bag. Because if you think people are not going to find out now, because that's what's going to happen, it's all public now, if you're 14 years old, you can actually walk down a sidewalk, a street, anywhere in the state of Missouri, carrying any type of a firearm. Until you brandish it, until there's intent, nothing can be done. It is our law in the state of Missouri. And I realize that this was yanked out of the original bill. I understand that. I know it's very controversial. And I'm actually shocked I'm carrying it. But I cannot leave this building without representing my people who used to think it was safe to just go to Target and not have somebody who's only 12 years old block you at the grocery store and put a gun to your head. And the other part about that, and it's not just happening once in a while, twice in just in 1 week, is that these kids, these children, are going to make a vital mistake that may cost them the rest of their lives. And I don't want to see that either, because I know they can be saved. I know, because our governor has talked about getting a state-of-the-art youth center. We're going to work on prosecuting. This is just another tool to help us, because we can't do anything. And when my police officers look at me and ask me for help, when my constituents look at me and ask me for help, I said, all right, I'll try this. Let's see what happens. And I'm ready for inquiries, because I have 15 minutes, and I move for its adoption.
Lady from St. Louis City has moved for the adoption of House Amendment 6. Further discussion, gentleman from St. Charles.
Thank you, Mr. Speaker. To speak on the amendment, please.
Please proceed.
Thank you. This is tough. It's a little philosophical, which is kind of within the wheelhouse that I tend to travel. It's easy to look at an amendment like this and think, yeah, that makes sense, right? Why would a 15-year-old need to be carrying around a gun? I think most of us would probably have that initial gut reaction. But you dig deeper. And like many things in this building, when you dig deeper, you find that it's a lot more complicated than it looks on its surface. This has Fourth Amendment issues. It has, obviously, the Second Amendment issues, and it has Missouri Constitution issues. I'm not sure we can even do this with the open carry law that's within the Constitution of the state of Missouri, but setting that aside, is it good policy? Is it good policy to basically start with the assumption that simply having a physical item is automatically causing harm, regardless of how you're using it and regardless of your age? It's not something we tend to do in other areas, except for guns. We have enhanced crimes if you happen to have a gun in your pocket when you go to the store and you steal a bar of candy or whatnot. You could be charged with an extra crime because you had a gun on you. And that's concerning to me on a very philosophical level, because we are putting in our statutes the mere concept that having a weapon is in and of itself concerning. That there is no possible reason for you to have that weapon unless you're up to no good. And while it may be intuitive that the 14-year-old or whatnot has no legitimate purpose, doesn't actually mean they're going to harm anyone. We don't know that yet. And generally speaking, we don't charge people with crimes because we think they're going to hurt someone. We charge people with crimes because they're doing something that is trying to hurt someone, or they have previously hurt someone. So I think just there is enough for me to have some pause. But then we start thinking of the practical implications here. And think of a situation where a kid who maybe is up to no good is carrying a gun, and a cop sees him and stops him and thinks, man, this kid's up to no good. I think he might be doing something on his way to a crime. And so the cop stops him and maybe does a search into that stop and finds he has a gun. And you think, oh, that's fantastic. The cop can take that gun away from that kid. He can't commit the crime. Well, certainly one way that can turn out, but you know what another way that could turn out is? That scared 15-year-old kid who is carrying a gun for maybe a nefarious purpose might think, oh no, I'm about to be charged with a serious crime for having this gun. I guess I better use that gun on that cop to make sure that I don't get caught. And now we're creating a situation where the law enforcement officer who's just trying to keep this kid out of trouble is facing violence for no reason other than that we put them there. I don't think that's the intent here, but that's very much what we could run up with here. The point of laws in general, the point of prohibiting conduct, is because it is harmful. That is our charter, is to protect residents and secure their liberties. We can't do that when we are trying to speculate what types of conduct they might do in the future. And while it might be easy to say, well, you know, we don't trust kids with all kinds of other things, we don't let them drink, et cetera, generally speaking, in most cases of a first infraction of minor in possession or the like, you don't have serious crimes resulting of that. For some reason, we think it's different because it's guns. Because you say, well, guns are intended to kill, and so we have to be more serious and more harsh in those terms. And I get that. I get that mindset. It's easy to walk down that path. But isn't that what we've done with drugs, with other areas where we say that, oh, well, if someone is going to do this one thing, we think that that's going to lead to something else, and that something else is bad, so let's crack down on that. And what have we seen? We've banned every drug under the sun. Has that stopped crime? Has that stopped people from even using drugs? No. No, all it's done is put more people in prisons that may or may not have actually gotten around to hurting anybody. We can always say that if we had stopped someone early on in a process, and if only we'd locked them away, some subsequent bad act wouldn't have happened. That's true. But that's true of anything. Every one of us in this room is capable of evil. And we could find a reason to lock up any number of people here because we think they're up to no good. It's not good policy. It's easy. It's a quick way to put a Band-Aid on a real problem, which I think we're having in our cities. But it doesn't fix the underlying rot that brought us here. It doesn't fix the fact that there's still some 14 or 15-year-old kid that's out there, probably up to no good. All it does is put our law enforcement officers in unnecessary danger and really opens the door to a whole lot of other concepts surrounding firearms that we just don't want to open that door to. Because we know that people are afraid of weapons. We know that there is a history in this country of going down that path too far with good intentions to start. It's not what we want to do today here, and that's why I'm against this amendment. Thank you, Mr. Speaker.
Further discussion. Gentleman from Pulaski from a microphone other than your own.
Thank you, Mr. Speaker. To speak on the amendment to the amendment.
Please proceed.
Mr. Speaker, I want to remind us what we're doing here today. We're talking about making sure that people are held accountable for their actions for violent crime, and so that people aren't able to commit violence against each other. And I feel like a solution that instead says we're going to criminalize conduct that would otherwise be lawful, someone under 18 possessing a firearm on public lands, that could be a conservation area, a public park, and now we're saying the possession of it alone equals unlawful use of a weapon. That seems problematic. And to the point that was just made, what is otherwise allowed by law? Usually we have laws that say, hey, this conduct is prohibited, but what is otherwise allowed by law? Well, it was otherwise allowed that you would carry a firearm. So I think there is a serious enforcement and vague problem, but I also want to caution everybody to say, if we're trying to solve a problem, why do we keep identifying inanimate objects as the one who's responsible for the murder, the violence? It's a human being. A human being is accountable for their actions. And we have a lot we talk about where, people kind of laugh at that. We say it shall not be infringed. The Second Amendment should not be infringed. People sort of mock that, right? But it's important to us that we remember that there's a reason why we have these constitutional rights, and it's to protect the people from the government. And so for all those reasons, I'm not going to be able to vote for this amendment, for the construction of it and the principle of it, and the core value I have of it. And so I'm going to vote no, and I'm going to ask all the members of this body to vote no with me. Thank you, Mr. Speaker.
Further discussion on House Amendment 6. Gentleman from Taney.
Thank you, Mr. Speaker. To speak on the amendment to the amendment.
Please proceed.
Thank you, Mr. Speaker. Every day that we're in session, I come in here, and because I served in the United States Army, I literally salute that flag. And I remember the men and the women who've died to protect our constitutional rights and our free republic. I remind the body and the author of this amendment to the amendment these 4 words: shall not be infringed. Thank you, Mr. Speaker.
Further discussion on House Amendment 6, House Amendment. Gentleman from Pike.
Thank you, Mr. Speaker. From a microphone other than my own.
Please proceed.
Mr. Speaker, I appreciate the amendment to the amendment maker's attempt to do what she believes is represent her district as well as she can. But the fact is, the people in my district should not be penalized and lose their rights because of something that's going on solely in her district. And I want you to remember that. If you vote yes on this amendment to the amendment, it's your constituents that will be affected, and they have not done anything to deserve that. And I would just like to remind the body of that. I'll be voting no. Thank you.
Further discussion. Lady from Jackson.
Thank you, Mr. Speaker. May I please inquire from the gentleman from Pulaski?
Does the gentleman from Pulaski, from a microphone other than his own, yield?
I'm not sure which gentleman from Pulaski she's referring to, Mr. Speaker.
You, sir.
Then in that case, I do yield.
Please proceed.
Hi, gentlemen. How are you?
I'm not sure. In all my time as a legislator, I received an inquiry from you as representative, so
Well,
I'm doing well.
congratulations.
The time has finally come.
Okay. Well, I'm glad you brought up the purpose of this bill, because it's clearly not to prevent violent crime, is it?
The purpose of the underlying bill is not to
Right.
prevent violent crime?
Right.
Well, that's a really interesting question. How do we prevent violent crime?
Well, I mean, we have lots of data to do that, and we have lots of ideas and lots of amendments that my side of the aisle have put together that we are not being heard.
Yeah, there are a lot of different points of views on what causes violent crime and how
Right.
to prevent it.
There sure are.
I think that, I think I said in committee, I'll reiterate my theory on it, that somebody murders somebody else when evil overtakes their heart. And there are a lot of devices that could be used for murder. And so unless we ever address
What's
those
the
issues...
most common one in the United States?
What's the most common thing that uses in murder?
Right.
You tell me. I don't know. I don't remember the statistic.
Firearms.
Did you just make a Count Chocula impression?
Yeah, you know why? Because this entire conversation is ridiculous. This has become a parody. We are literally talking about public safety, and I have, for the last 3 weeks, for the last 2 months, I have been hearing about how much our children are in danger from drag queens. And now I'm hearing that guns aren't an issue. Guns aren't killing the kids in St. Louis and Kansas City. and that this bill is going to affect everyone in the state. And that's not the intention of the bill, right? It's only to affect St. Louis and Kansas City, where all the murder happens. Not Branson, which has exponentially high crime rates if you look. Like, check out the data. It's happening everywhere. And we are making it easier for children to carry guns. But no, let's not let them determine their gender. Let's not let them experience a drag show, because that is indoctrination. But give them a gun and put it on a Christmas card.
Gentlemen, please state your point of order.
Speaker, the conversation is well taken here. We are discussing firearms, but we're not discussing drag shows. I'd request the lady to remain on topic of firearms or the crime prevention, what we're discussing.
Further discussion on the point of order. Lady from Jackson.
Yeah, that's really interesting, considering how many members of this body, including that gentleman that just spoke, testified in committee that drag queens are a danger to children. Public safety.
Lady, I would remind the body that the bill concerns the prosecution and firearms. The amendment contains firearms and not drag queens. If we could please keep the discussion to the topic at hand, it would be appreciated.
So back to protecting children.
Of course.
Tell me how us not having this amendment is going to help protect children. How children being allowed to carry guns. Because we're saying minors, but they are children. These are children that I've heard for the last couple weeks are not allowed to watch rated R movies, but we're going to let them carry a gun. Tell me how that's safe.
The question of rated R movies. Yeah, I think that should be up to the parent. And I think, when I decide if my child is mature enough to carry a rifle across property to hunt, and then you could say, well, the hunting's prohibited. I'm not sure it totally is. It says otherwise allowed by law. But let's say going to the spot they're hunting. If I say that my teenage son or teenage daughter is mature enough to do that, and they can hike up to their hunting spot with a rifle, then I think that should be a decision I make as a parent.
Should they be able to take them to school?
Should they be able to take a gun at school? Mm-hmm. So this amendment, I don't think they could take a gun at school with or without this amendment. So this amendment doesn't really affect a child's ability to bring a gun to school. Does it?
I'm asking, do you think that they should be able to?
Yeah, I think a child should bring a gun to school.
Because, if we're saying shall not be infringed.
No, I don't think a child should bring a gun to school.
Okay, so you do think it should be infringed when it comes to school?
I was saying that I think that people laugh at that. We say,
but there are exceptions, right? What about a courtroom? Shall we infringe gun rights there?
To carry a gun to the courtroom?
Right.
Yeah, I guess that's what we're arguing about, is what do we think actually is violative of the rights? And I would say that that teenager who's on public land with a rifle, that should be up to the parent. And then also would say, you said, well, how does not having this amendment protect children? I would say, well, does this amendment, we want to get after the juvenile issue. I know that we do, and we're going to. I think that we are. But I could say, okay, how does
Just
the law...
not on this public safety bill.
Well, I could say, how does a law that says if I carry a firearm on public land protect people? Because it's already law right now to shoot somebody. It's already law to murder. It's already law to commit assault. So that person who is not inhibited by those laws, why would they be inhibited by carrying on property itself?
Then why do we have any laws at all? Because if we're saying, if the crux of the argument against common sense gun control is people are going to murder, criminals are going to crime, then why have any laws at all? Why?
Why have any laws at all? I think a lot of us would argue that we should have fewer laws.
Okay.
But we should have some laws that are effective, that address some things that, and what we think is commensurate with our values. Common sense. What's common sense? I think we would agree on what's common sense. See, I would say it's common sense not to have a law like this. Because I'm not really sure how to enforce it. I'm not really sure when I'm committing the felony.
Do you think it's common sense to support law enforcement who agree that things like this would help them in places like Kansas City and St.
I think
Louis?
it's common sense to support law enforcement, but it's never our job to do entirely what any group says. It's always our job to say, you've got a point of view, you've got a point of view, I got a set of values, I have my constituency, I have my set of, and so we kind of make fun of that, but we all do have a set of experiences that are different. That's important to bring those to bear. I have all these things, and I'm going to balance them. And after I consider them, I'm going to look at this language, and I'm going to go, is this language good or bad? And so I say, I don't like it, right? This is my personal opinion. And we can say, we can't compromise it, we can't agree on it, and then we're going to vote on it. And I think that's okay. We all bring different perspectives to this problem. And we all bring different things, values that we weigh differently to the problem and how we see it.
Right.
And so I think that I can support law enforcement, but I can also say I don't agree with every single thing a certain group asked me to do. And actually, there's no group that I'm going to agree with 100% of the time. But there are lots of groups, all groups I'm going to listen to, and I'm going to consider their perspective. But it's never my job to say, well, me supporting law enforcement means I'll do everything that every police officer says. I'll also throw out to you that not all police officers have the same opinion.
Even if it's based in evidence, like it's evidence-based practice and it's supported by data and national studies, international studies, and crime reduction.
So I think that there is data, that there is a crime problem in St. Louis. I think that there are enough people who told me that we've got an issue with young people carrying firearms and committing crimes. I don't think this is the way to solve the problem. And I
By
don't,
taking the guns away from them, that you don't think that's the way to solve the gun crime
that's interesting.
problem?
So are we taking the guns away from them? So I think there are lots of cases right now, unlawful use of a weapon cases, tons of gun cases that are not being charged and are not being adjudicated. So let's say we do this. Let's say that the solution to the problem is we go, let's criminalize somebody under 18 having a firearm on public property. Let's make that a felony. Not to mention the problem of how do we charge a minor and then certify it like logistically. Not to mention that problem. Let's say we do that, and that was our solution. And we didn't have anything else in this crime bill. Would we solve crime? No. Because even those felonies, which I think are vague and difficult to charge, would go into the backlog of cases that are not being prosecuted. So the people in the process are taking responsibility.
We're not talking specifically about the special prosecutors right now. We're talking specifically about minors having access to guns and being able to carry them on public property. And you're saying...
Actually, I'm answering whatever question you have. So whatever you want to talk about, that's what I talk about.
Sir, that was not my question. I'll remind you that this is my inquiry. My question was...
I always want to grab the microphone and go, no, this is my inquiry now. But I'm not going to do it. Go ahead, sir.
I think we're done. Thank you, Mr. Speaker.
Thank you.
Further discussion on House Amendment 6. Gentleman from St. Louis City.
Thank you, Mr. Speaker. To speak on the amendment.
Please proceed.
Mr. Speaker, I appreciate it, and I've said before on the floor, if you just live long enough, you wind up being the oldest person from your city or county. So I am the longest living citizen of the city of St. Louis and also have a lot of rural connections in Crawford and Washington County. There is a big divide in this state when we need to talk gun issues between urban and rural. It's just something we're going to have to address. When we talk about the crime rate in the city of St. Louis, and it has been bad. I was born in 1959. I can tell you in 1960, we were talking about it, the 1970s, 80s, 90s, 2000s, 2010s, 2020s. We're still talking about it. The murder rate is out of control. The number of murders is out of control. However, and this is not an excuse, it's just an explanation of statistics, we have, look this up, we have 200 murders a year in the city of St. Louis like clockwork. It tipped up, it spiked big time in the 90s, got around 325, somewhere in that range. We celebrate when it gets down to 170 or 180 in a year. The reason why that murder rate keeps going up is every single year since 1959, the year I was born, we lose population. The numerator stays constant. It's 200. The denominator keeps getting smaller. So there aren't any more murders. And the murders at 200, it's unacceptable. 150, it's unacceptable. 50, it's unacceptable. But it's the reality of the last 60 years. So you have to at least put that in your data bank and say, okay, just because the prosecutor now, the murder rate is high. It is not the number of murders. It is the declining denominator. I do think the city would benefit from the special prosecutor, and I know that is part of this bill. Equally so, and not secondarily, to address what this lady from St. Louis amendment addresses is critical. Mr. Speaker, if I could I inquire of the gentleman from Newton very briefly?
Does the gentleman from Newton yield, and do you have a clear path?
Yes.
Please proceed.
Appreciate you taking the inquiry. So, real quick, we get that talk about public lands, rifle, my kid's going to go out hunting. Just real quick. Yeah, I get it. If you lower that mic. Thank you. Could you just explain to the body, and I think I have a pretty good understanding of this. Actually, I have a very good understanding of it. The hunter safety education course How does it work briefly?
Well, it really depends on who the instructor is, to be honest with you. But a hunter safety course is something that even kids can take to get a certification, to be able to get a hunting permit, and various different ways that they can do that with Missouri Conservation.
Yeah. So there's a regulation that goes through, and at what age, you got that off the top of your head, that you kind of have to take it, right?
I think as young as 6, if I remember right.
No, you can go on a youth hunt, so I don't want to bait you with the question. It's at 11, you have to do it. So
right.
The gap is between 11 and 15. I think it's interesting to note, and I think you and I even talked about this offline, that to get the hunter safety course, the kid, 11 to 15, and a bunch of these kids we're talking about are between 11 to 15, have a 2-part course. You got to do an online thing or a workbook with your parent or guardian, and then the next day, week, whatever, you bring your certificate, and then you go through, generally like in my turf, it's at Bush Wildlife, but it's throughout the state. This is very common. Without that, passing that, you're not allowed to hunt on public land, correct, if you're a kid?
Yes, that's correct.
And not just a kid. That was the part I think is, for all of you to say, this hunter safety thing is for kids, critically important. It's anyone born after January 1, 1967. So let's say you're a 52-year-old guy, and you just said, I'm going to go deer hunting with my buddies for the first time, I'm going to go duck hunting, whatever it is. Even that person has to take that online course, correct?
In Missouri.
Yeah, I appreciate that. Great. Now, that thing when I was questioning you on, because I did think you were a little disingenuous on your striking that word and not telling everybody. Let's talk about a quick modification when I'm hunting. So you're our Sportsman Caucus leader, amongst others, so I know you're an avid hunter. Have you rabbit hunted this year yet?
I have not. I haven't been rabbit hunting in a long time, actually.
All right. Well, I was a couple weeks ago, and I think I like my Remington 870 12 gauge. It's a standard shotgun. Good choice. It's the workhorse of the industry. When I go rabbit hunting, how do I have to modify that weapon?
Probably how many. I don't rabbit hunt a lot. So in Missouri, I don't even know if I've ever rabbit hunted in Missouri, but where I grew up, I think it was limited by how many shells you could put into the magazine.
Yeah, that's correct. So, the magazine, if I don't modify the shotgun in any way, shape, or form, it'll hold 5 shells. But if I'm out, let's just say, rabbits or ducks, I better have that plug in my magazine to limit me to 3 shots, just part of the sportsman thing. I would say that that's a bit of a regulation on a firearm. So if I'm a kid, I got to go through this class. If I'm any age after 1967, I got to go to this class. The kid
I think
also
there
has
is
to
one
go.
exception for apprenticeship, though.
For the youth hunt and stuff.
Yes.
Yeah, there is. But the point was made to just have my kid, I think he is ready to go hunting at 11 or 12. That's true. But not till he goes through this. So I appreciate that greatly. Thank you, Mr. Speaker. If I could inquire briefly of the gentleman from Washington, McGurl District.
Does the gentleman from Washington, McGurl District yield?
I do.
Please proceed.
I appreciate it a lot, gentlemen. You and I share a lot of my country roots together. So you're from Washington, my people on my mother's side for 250 years. Old Mines, Potosi. We spend my entire summers down in Steelville, Crawford County.
Oh, yeah.
So I just want to go over it. We've talked about this because, it's strange. So my district in the city of St. Louis, my entire 37,000 constituents are within about 1.1 miles square. I can walk from my southern border to my northern border in under an hour, the entire district. I know some of y'all are thinking, that's insane, right?
Oh, yeah,
but
I don't
it's
have
reality.
that privilege.
You do not have that privilege. How far do yours go? Because I see your signs.
It's about 70 miles that I have to drive from the south end to the north end.
Correct, and you and I know we both love Washington County, and I can guarantee you would say Washington County, at one time it was the state's poorest county, and it's still very poor, the rural parish workers, etc. So the issues of poverty exist in Washington County as much as they would, for example, in Dutchtown in my district. I think you would agree with that.
I would say that's probably correct.
Drug addiction, drug selling, drug using.
Yes, we have what
Big time.
everybody else has.
Big time. The one thing that is very different is gun violence. So I know if it's Crawford County, we might go a year in Crawford County. We might go 10 years and have one murder. It was the canoe floater guy. It made, national news. In Washington County, can you recall the last time you had a murder?
Well, I'm trying to think. It's been a while. I will say that. I don't recall the last one.
Okay, since I've been here in 5 years, just in my little 1.2 square mile district, I've got a dozen murders at least, multiple armed carjackings. I think I'm probably still the only member that can say somebody rolled up in front of their house and just emptied their clip into my house, right? So that was Mother's Day evening, May 2020. There is a level of gun violence that exists in the city, I think you would agree, that does not exist in the country.
That is correct.
And I would suggest to you, and everyone else listening to this, that is because there is this difference, not just cultural, not just poverty. It has to do, in my opinion, in large part with the density of the population. When we got an issue with each other, and we live in Washington County, and, there's cooler heads prevail, and you live 300 yards from me, as opposed to 37,000 people live in 1 square mile. Tempers flare much more quickly. I appreciate the inquiry.
But
I
would like to add one thing.
Absolutely.
There's a little difference in that. Yes, there's a difference in the area from the city of St. Louis to Washington County or any other rural third-class county. But some of the differences. I grew up with guns. I mean, we had loaded guns in our house. I was at 10, 11 years old, I was squirrel hunting and rabbit hunting.
Same here.
So, I mean, I always knew to respect what a gun could do. I was taught you don't point at anybody. When I was in the Boy Scouts there in Old Mines, the NRA come and give us training. When we was at our scout camps, the Highway Patrol came and did demonstrations with their weapons.
I agree with all those things. Hey, Dick, I have all those same experiences. So I was on a little .22 rifle team for the Carondelet YMCA in 1967 or something. I'm like, isn't that crazy? I'm shooting a rifle in the basement of the YMCA. But times have changed, and we need to address this. I appreciate it. Thank you, Mr. Speaker, to speak for just a moment more on this amendment.
Please proceed.
If you think, Mr. Speaker, and the rest of this body, if you think that just appointing a special prosecutor is going to dramatically affect crime in the city of St. Louis, I can tell you it will have some effect, I do believe. It will not have a dramatic effect, and I base that upon 200 murders on average for 50 years, no matter who the prosecutor was. So there is an elected point to this. So that's important. I just think that we have to look behind and say there are differences between rural guns in today's culture, not when I was a kid. It was the same back in the 60s. We walked around, we shot guns, we respected guns. We would have BB gun fights in Carondelet Park. None of this stuff would be acceptable anymore. Things have just changed. That's why we need to address this. And this is not, nobody ever wants to quote a well-regulated militia. I don't even need to go down on the Second Amendment. We're only talking about youths. If it was something to change the law that would just give law enforcement and parents and local people in the city of St. Louis and Kansas City and beyond a chance to just say it's unreasonable that a 13-year-old can carry a gun just down the street. That's not a heavy lift. There's a big difference between that and squirrel hunting in Washington County. To the gentleman's point from the Lovasco district, it's just an inanimate object, and why should we have any controls on it? I'm like, why do we say you have to be 16 to drive a car? Why do we say you have to be 21 to drink any alcoholic beverage, right? It's just an inanimate object. It's just sitting here. We do this on so many things. This is not a heavy lift. If you would just look at the cultural difference, the rural-urban divide, address it just for youth that should not be carrying firearms. Thank you, Mr. Speaker.
Further discussion on House Amendment 6, House Amendment 1. Gentleman from Webster.
Thank you, Mr. Speaker. To comment on the amendment to the amendment.
Please proceed.
Thank you, Mr. Speaker. I believe the gentleman from Pike and the gentleman from Pulaski make excellent points. Should this proposed law, be effective for every jurisdiction in the state? We don't have this issue where I live. What do we do about enforceability? I think the gentleman from Pulaski makes good points. What happens, what do we do with the children? These are children. What do we do with the children after this law might be implemented? Have we figured that out? Have we determined how they're dealt with when this particular language might go into effect? However, I have heard the amendment maker's description of the problems in her jurisdiction. They are almost inconceivable to me that kind of conduct would occur in our state. Last night, I heard the Republican response to the so-called State of the Union speech, and that lady said the people expect of their elected representatives common sense. The Heller decision that actually confirmed the personal right to keep and bear arms, also clearly stated the Second Amendment is not unlimited, as the First Amendment is not unlimited. There are restrictions on the use of firearms. Children can't buy firearms. Felons can't possess firearms. The mentally ill can't possess firearms. The point is, the Second Amendment, like all the amendments, have some limitations. So I'm a no. I believe the gentlemen I've described have made good points. But I also think this matter merits consideration, further consideration, and I would encourage the body to try to find ways to do that. Thank you, Mr. Speaker.
Gentleman from Jackson.
Thank you, Mr. Speaker. I move the previous question.
The gentleman from Jackson has asked that shall the question under immediate consideration be now put. All those in favor will vote yes. All opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 105 yea and 38 nay, you have moved the previous question. Lady from St. Louis City, recognize to close.
Thank you, Mr. Speaker. I want to make sure people know that I'm not originally from St. Louis. I actually grew up here in Jefferson City, so I am not urban. I'm actually small town. The next thing is, everyone kept saying, this is a state issue. And the reason is because the Missouri Chamber of Commerce made it their number one thing that is keeping businesses from moving to our state, and it's getting businesses that are moving away. Somebody told me they were in a bar in Denver, and the person next to him said, where are you from? They said, St. Louis. They said, oh my God, is it really that bad? Do you get shot every time you drive down the street? But I wanted everyone to know that if you have an adult with you, this legislation does not say you can't carry a gun. It just says you have to be with an adult. But I need everyone in here to know that before you push that button, you need to think long and hard about the police officers that are in jeopardy. And last, maybe this is the wrong piece of legislation. Next piece of legislation should be the right for the city of St. Louis to decide our own gun laws. 5 members standing. I'd like a roll call vote.
You'll have your roll call vote, lady. The lady from St. Louis City has moved for the adoption of House Amendment 6. A roll call vote has been requested. All those in favor will vote yes. Those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 39 yea, 104 nay, and 1 present, you have failed to adopt House Amendment 6 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Jackson, Sharp District.
Thank you, Mr. Speaker. I have an amendment ending in .87H. It's been distributed. I move for its adoption.
Gentleman from Jackson has moved for the adoption of House Amendment 7 to House Amendment 1. Gentleman from Jackson.
Thank you, Mr. Speaker. What you have in front of you is Blair's Law. This is a bill that we have heard in the House several times over the course of the last 2 or 3 years. It's one of those better examples of some really good bipartisan legislation. I know this conversation has been divided here this afternoon, but this is a pretty good bill that I think we can all get behind. For a little backstory for some of the freshmen that are here, back in 2011, a little girl named Blair Shanahan Lane was killed when a bullet came from the sky, striking her in the neck, killing her instantly on 4th of July when she was playing with her family in her backyard. Luckily for her family, they were able to match up the bullet that was lodged in her with folks that were caught shooting in the air nearby. Some of you may not know, but in the city of Kansas City, we have an extremely bad firearms problem with folks shooting their guns in the air in a celebratory fashion. Every year we try to combat this by asking the public not to do so, but that doesn't seem to be working. This is Blair's Law that will create the state offense for discharging your firearm into or within city limits. It is a priority of the city of Kansas City, a priority of the mayor's office, and a priority of the Kansas City Police Department. We are trying to add some teeth to this legislation. Right now, if you are caught doing this in the city of Kansas City, it's only punishable by a city ordinance violation. People are having their lives taken from them. I know I have plenty of people that are emailing you, and I'm sure you all probably get several emails too about bullets coming through their windows, bullets coming through their walls, and we have to do something to try to combat this. I'm hoping that the body can join me today in trying to make an effort to stop that.
Further discussion on House Amendment 7. Gentleman from Jasper.
Thank you, Mr. Speaker. We've heard this bill a couple of times on the floor. It has been voted out of the House on at least one previous occasion. The amendment handler has spoken with me. I understand there's kind of a visceral reaction anytime you mention gun, but I can't think of anything more tragic than a child losing their life, particularly when they're not involved in any misconduct. This is something that was easily preventable. I support the gentleman's amendment.
Further discussion on House Amendment 7. Gentleman from Pettis.
Speak on the amendment.
Please proceed.
It's been said already, but I think this bill's been heard like 10 times, and so it's been vetted. Every time we bring this bill up, it gets caught up in this firearm debate. It gets caught up in the gun-free zones debate. During the summer when I'm out at the farm and I'm working, there's a lot of time to think. And I always come back to this bill on why we have not been able to do the right thing and pass this bill. This is an opportunity to get this bill onto, hopefully that'll be a bipartisan bill, and get this done for that family and for future families as well. So this is common sense stuff, and I urge the body to support this amendment.
Further discussion on House Amendment 7. Gentleman from Benton.
Thank you, Mr. Speaker. I would like permission to speak from a mic other than my own.
Please proceed.
I would like to inquire the gentleman from Jackson, the amendment maker.
Does the gentleman yield?
I do.
Please proceed.
Good afternoon, gentlemen.
Good afternoon.
This language seems pretty familiar to you and I believe, in this chamber.
Absolutely.
We've worked on this bill 2 years. And part of this was on a bill that went to the Senate the last 2 years. Is that right?
That's correct. It came out of the House on 2/3 reads the past 2 years with overwhelming support to go to the General Laws Committee on the Senate side.
And gentlemen, the first year it went to the Senate. We did get a Senate hearing over there. Last year we sent it to the Senate and it did not go anywhere.
Right.
But the common thing of those years, we saw this young woman's mother come and testify on this bill, both in the House committee and also in the Senate committee. Did we not?
We did, and luckily for us, we were able to bring down the investigator and the detectives that worked that case specifically.
Well, gentlemen, I appreciate you bringing this amendment. I appreciate the gentleman from Pettis and his support for it because he was chairing the committee that it came through last year. And I want to thank you for bringing this amendment forward. It's common sense. It's something that needs to be done. And I think it would be a great accomplishment for this amendment to go on this bill. Thank you, gentlemen.
Thank you, gentlemen.
Further discussion on House Amendment 7. Gentleman from Clay.
Thank you, Mr. Speaker. To inquire of the gentleman from Jackson.
Does the gentleman from Jackson yield?
I do.
Please proceed.
Gentlemen, I was just looking for a little specifics. I wonder if you could tell me how many times specifically Blair's Law has been passed when it was offered here in the House.
Sure. So I've been here since 2010, but the bill was offered before I got here. It's one of those bills that I sort of inherited from the previous gentleman from the 36. Well, the numbers changed since then. But in 2010 or 2020, me and the gentleman from the Bearded District, otherwise known as Senator Schroer, and the gentleman from the Independence District, the Rowland District, presented this bill together in the General Laws Committee. It was voted out with the vote of 12-1. The following year, in 2021, me and the gentleman from the Rowland District presented the bill. This time the mother was able to attend and give her testimony, and that bill was voted out 15-0 in General Laws Committee.
Thank you, gentlemen.
Further discussion. Gentleman from Andrew.
To inquire of the amendment maker.
Does the amendment maker yield?
I do.
Please proceed.
Gentlemen, thank you for bringing this bill to us, but if I could borrow your second here. On line 27, paragraph 4, it says a person who commits the offense of discharge of a firearm shall be guilty of. It doesn't say unlawful discharge of a firearm. Apparently this would make any discharge of a firearm a crime.
A person who commits the offense of a discharge of a firearm shall be guilty of. I mean, to me that reads correctly.
Do you mean an unlawful discharge of a firearm, or do you mean discharge of a firearm? There's a difference. If I'm on my property, I shoot my firearm, I discharge my firearm, am I guilty of a crime? The answer should be no, right?
That's correct. Yes, sir.
Okay, but according to this, if I discharge my firearm, that's an offense.
Right. So give me an example of so I can be clear what examples
What
you're
I'm saying
to.
is your bill has an error in it by leaving out the word unlawful. It should
Okay.
say unlawful discharge of a firearm rather than discharge of a firearm. Line 27.
Right. It does say unlawful, sir. On line 8, a person commits the offense of unlawful discharge of a firearm with criminal negligence. So I'm not sure where exactly your home district is exactly, but I don't think that prosecutors will be looking to prosecute with Blair's Law in some of these examples in rural Missouri. This is really something that for our urban cores really need to help on. So I'm not sure if this is going to apply in that example.
The point I'm making here, gentlemen, is that in one place you do say unlawful discharge of firearm, and I agree with that. But later on in paragraph 4, a separate paragraph, which could be taken by itself, it says discharge of a firearm is a crime. It doesn't say unlawful discharge of a firearm as what it should say.
Well, respectfully, gentlemen, this language has passed through several hands of several attorneys that are criminal attorneys. I do think I trust their judgment, sir.
Well, you might trust their judgment, and attorneys make mistakes as well. I know we all do. I'm just saying I think that this is an error in this bill and would make anyone discharging a firearm guilty of a crime.
Yes, sir. This bill this is the same language from over 4 years, gentlemen.
Well, maybe it's been overlooked for 4 years.
Perhaps.
Perhaps it has. I don't know. I appreciate you bringing this bill, but I think that we need to look at that paragraph 4 more before we go and pass this amendment. Thank you, Mr. Speaker. To speak on this amendment, while I agree with the intent of this bill, I do believe that paragraph 4 is improperly written and that we should vote this amendment down because it is improperly written and will not do what the amendment maker intends and would make people who aren't discharging their firearms illegally criminals. Thank you.
Further discussion on House Amendment 7. Gentleman from Jefferson.
Permission to speak from a microphone that is not my own.
Please proceed.
I am new here, but how quickly would it take to change the one word, have it added to the amendment? Is that a possibility?
Gentlemen, that would be an amendment previously amended and previously amended to the third degree. The amendment is not well taken. Further discussion on House Amendment 7. Lady from Jackson.
Thank you, Mr. Speaker. To inquire the amendment maker.
Does the
amendment to the amendment, sorry.
The amendment to the amendment maker.
Jackson.
Gentleman from Jackson, do you yield?
I do.
Please proceed.
It's like, good evening. Trying to see if it's day or night or what. So thank you so much for all your work on this, this Blair's Law. I recall it came through Rural Community Development last year, a committee I serve on.
That's correct.
And you have teamed up with the gentleman on the other side of the aisle on this. We heard from Blair's parents, and there was not a dry eye in the room.
That's correct.
And the chair of Rural Community Develop, who spoke earlier, vowed to get this across the finish line, and we were committed, and then unfortunately it didn't. So I really appreciate you not giving up, continuing on this. It is a problem in Kansas City. I always see you on the news around the 4th of July and New Year's Eve, and thank you. Thank you for this. I think that if you serve on that committee and you hear from Blair's parents who come here year after year sharing their story, You know, it's really touching. So thank you. Anything else you wanted to add?
No. It's been pretty difficult getting this language all the way to the finish line. We've gone through several different committees. It's gone through General Laws Committee in my first 2 years here. It's gone through the Rural Community Development Committee also the last 2 years. So this has been a bill that has been, I would think, as vetted as one could vet it. And it probably should have passed 2 years ago when we had a hearing on the Senate side, but we literally ran out of time because it was voted out of committee on May 7th, a week before we were scheduled to end. So I'll just say these numbers real quick for the body's edification. It's been voted out of this very chamber by a vote of 109 when it had several controversial amendments attached to it, and it came out clean last year with a vote of 131 yeses, 0 noes, and 5 present. So this is a bill that should have strong support.
I appreciate you sharing that. Thank you so much. Mr. Speaker, to speak in support of the amendment to the amendment.
Please proceed.
Thank you. As I mentioned, I heard this in rural community development, heard from Blair's parents who come here year after year. This is had bipartisan support for several years in a row. I will be in support of the amendment and encourage others to do so as well. Thank you, Mr. Speaker.
Further discussion on House Amendment 7. Further discussion on House Amendment 7. Gentleman from Pike.
Thank you, Mr. Speaker. To inquire of the amendment to the amendment maker.
Does the gentleman from Jackson yield?
I do.
Please proceed.
Thank you, gentlemen. I was reading on, I believe it was line 9 or 10, and it specifies that would only apply if that was fired inside the city limits of municipality. Is that your understanding of it?
Yes, it is.
So it would not apply to rural areas necessarily?
That's correct.
All right. Thank you, gentlemen.
Thank you.
I got Schnelting. Gentleman from St. Charles.
Speak on the bill, Mr. Speaker.
Please proceed.
To inquire,
Take your
my
time.
correction. Thank you, Mr. Speaker. To inquire of the gentleman from the 36.
Does the gentleman from Jackson yield?
Yeah, it changed to 37, but yeah.
Oh, 37.
Thank you, sir.
Moving up. Hey, gentlemen. Thanks for bringing this forward. I know I should probably slow down a little bit, but thank you for bringing this forward. I know you've worked really hard on it over the last few years. And this legislation, you and the gentleman from, you and one of the other gentlemen, thank you, had been working on this quite a bit. And then you also amended it to, I don't remember the bill number from last session, but my CCW on Metrolink bill.
Yep.
Got that passed. It passed the House. This is the same language that you had on it last year.
Same exact language.
And we passed it out of the House.
Yes, we did. I didn't mention that time. It's passed on the House floor several different times. I only mentioned 2 of them.
That's right. And we had bipartisan support on that legislation last year.
We sure did.
Same language. Just for the body's edification.
The same exact language.
It sounds like we're going to be able to fix the perceived issue here. Is that right?
I think we want to make sure that we're on a piece like this that has been vetted, and I've been working hard, and many folks in this chamber have worked very hard on. We should go ahead and try to make it right if we can. So I think we're taking that time right now to make sure the change is fixed. Or the fix is,
absolutely. And I'll let someone else who wants to talk to you inquire. Thank you for the inquiry, gentlemen.
Thank you, gentlemen.
Further discussion on House Amendment 7. Gentleman from Cape.
Mr. Speaker, to inquire the amendment to the amendment maker, please.
Does the gentleman from Jackson yield?
Yes.
Please proceed.
Thank you. We've talked about this bill before. I think I was in one of the committees when we heard it. It's a good bill. I know from my time in law enforcement, we would see these celebratory shots fired when I was City of Cape Girardeau working there. We'd see them on Halloween. We'd see them on New Year's Eve especially.
Yep.
Or sometimes people were just drunk out doing it. I know when the officers come to you and the citizens you've talked to in Kansas City, how many times do these instances happen in any given year? Do you know?
Well, the community I live in, it happens pretty often. It doesn't have to be New Year's Eve. It doesn't have to be after a big Chiefs win. It can be just on a regular day. And I got to tell you, these aren't just handguns that are being fired. I am hearing fully automatic weapons that are being discharged right around the corner. Yeah. And I got to tell you, my wife and I, we have a 19-month-old. When this starts to go off like this, we have to go downstairs.
Yeah, it can be very scary, and I know when I responded to cases where we'd find bullet holes inside of a house or where they went through a window, we had some near misses when I was in law enforcement for 30 years, and it's a dangerous thing. It's very scary for people, and it doesn't help your community when that's going on. And when you talked about this, and I think I'd got to meet some of the people that had come forward with that, I felt very sorry for them because they lost a lovely young lady, I believe, there, and it was just one of these happenstance things, and it was terrible. But I do appreciate what you're doing with this. And,
I wasn't going to mention it, but since you went ahead and said it, I don't want to take up too much of the body's time, but my very first year, my very first interview as being a state representative was from a reporter named Aviva Haberson, who worked for KCUR, and you can Google this right now if you want to. She was killed in her apartment, sitting by her window in Westport, Kansas City, when a bullet came through her window and killed her. And her coworkers didn't know where she was for days, so they went by her apartment and found her there unconscious. Terrible. So this happens more often, and this was 2 years ago. So this happens more often than what we think.
I think we're good from the time that we needed here, but I appreciate you bringing this bill forward, and I support it.
Thank you.
Further discussion on House Amendment 7. Gentleman from Jackson.
Thank you, Mr. Speaker. Next order of business, I ask you to ask the gentleman from Jackson to withdraw his amendment to the amendment.
Does the gentleman from Jackson yield?
I withdraw the amendment ending in .87H.
The gentleman from Jackson has moved to withdraw House Amendment 7. Further discussion on House Amendment 1. Gentleman from St. Louis City.
Thank you, Mr. Speaker. I have an amendment ending in .81H, and I move for its adoption. Amendment to the amendment.
The gentleman from St. Louis has moved for the adoption of House Amendment 8 to House Amendment 1. Further, gentleman from St. Louis.
Thank you, Mr. Speaker. This is a very simple amendment. I know this bill is touching a lot of large things. And one of the things I know when this bill originally started off, it talked about addressing the St. Louis City prosecutor. That has changed to the whole state. And as someone who live in St. Louis, understand there's several issues if you really want to talk about crime to really get to, but there's a lot of changes that's happening in the city of St. Louis. We have several elections coming up. What this amendment would do would change it from 5 years to 3 years as the changes that are happening in St. Louis City, potentially even new leadership, that this wouldn't put the new leadership hands kind of tied behind their back. And with that, Mr. Speaker, I close.
Further discussion on House Amendment 8. Gentleman from Jasper.
Thank you, Mr. Speaker. The amendment maker did speak with me. We have some understanding about what this means to both of us, and provided that that actually happens, I support his amendment.
Further discussion on House Amendment 8. Gentleman from Jackson. Gentleman from Jackson.
I have an amendment to the amendment ending in point.
Gentlemen, we are on House Amendment 8 at this point. We're further discussions on House Amendment 8. Seeing none, gentlemen from St. Louis.
To speak on the amendment.
Please proceed.
Speaker and body, I also live in St. Louis, and we're having a number of leadership changes that I think should be considered, and I think that's part of why the bill sponsor has considered reducing the time period here. So I would ask that we also respect his opinion and honor the amendment that the gentleman from St. Louis is making.
Further discussion on House Amendment 8. Gentleman from St. Louis.
To inquire of the amendment maker.
Does the amendment maker yield?
Yes, I do.
Please proceed.
Hello, gentlemen. How are you doing?
I'm doing good, gentlemen. How you doing?
What are your thoughts about this amendment?
Well, my thoughts on this overall bill is, it is, again, now we kind of open it up to the whole state. But if this were to affect St. Louis, I'm a big believer in local control. I also understand we have a crime problem. I think there's many ways that we could address this. But with local control, we have, like I say, outside of the city of St. Louis, we're reducing our alder people, going from 28 to 14, where we have professionals down there to really talk about policy instead of maybe speed humps and trash cans. And then a year after that, we'll also have another election of our circuit attorney. Who know what the voters will do, but if there is a potential of change of leadership, I would hate for any new elected official to have their kind of hands tied behind their back as things are trying to potentially change at the board, or the same leadership with new board members down there.
I do understand your points, and I understand that we do have a crime epidemic in the city of St. Louis, and something needs to be done. I do not want to infringe on the voters of the city of St. Louis, but something does have to be done. Do you have anything else to say?
No, I agree. Like I say, this is we shouldn't be, kind of having our hands in the business of St. Louis without really talking about the root cause. I do think addressing the crime that is happening maybe through the prosecutor is one angle, but there are several other amendments I know that we talked about. If you talk about drug court, in our area we have high poverty, and you can't not talk about crime without talking about poverty, talking about lack of health care, talking about lack of livable wage jobs. So as this process goes on, I want to make sure again that we're not tying the hands of at least my city and anybody else's city, where it's a 5-year period compared to a 3-year period, where we could revisit that in a much quicker time than having a 5-year period where the prosecutor or the special prosecutor will be in place of any jurisdiction.
Thank you. Thank you, Mr. Speaker.
Further discussion on House Amendment 8. Gentleman from Taney.
Thank you, Mr. Speaker. To speak on the amendment to the amendment.
Please
Thank
proceed.
you. Thank you, Mr. Speaker. I think, again, I return to the fact that the initial bill, House Bill 301, was thoroughly vetted in committee. We pored over it line by line. We made informed decisions. All of the committee spoke, offered their concerns, and I think to change it at this time, this would be a fundamental change. I do understand the representative's heart. I think it's definitely in the right place because he's trying to solve a problem within the community that he represents, and I do understand that. But I think we have to return to a well-vetted bill, and I think really that 5 years is probably the appropriate amount of time to solve the problem within that area, and I would just encourage the body to continue moving forward with the bill as we have it and keep it at a 5-year instead of 3. Thank you, Mr. Speaker.
Further discussion, lady from St. Louis City.
Thank you, Mr. Speaker. To inquire of the gentleman from Taney.
Does the gentleman from Taney yield?
I do.
Please proceed.
Good afternoon, gentlemen. Can
Good
someone lower that mic for me, please? I already don't have eyes. I need to have a clear vision. Thank you.
Do I look good?
I don't know about that. I wouldn't
Well,
say that
rats.
on the floor. You know,
I have
ethics
to
is a
fish
real
for
thing.
compliments, lady. I need them.
And you know, I said that I would not tell a lie, so I'm trying to keep that together. So, question
Okay,
is,
I finally got it.
in the 3-year time span, how long are prosecutors particularly elected across the state?
Oh, I don't know that. I've never ran a prosecutorial campaign. I've
So
never ran
you
for
don't
a
know
prosecutor.
what your county prosecutor, how long they serve?
No, I really don't. I just know that the bill was well vetted in committee, and I think 5 years is probably appropriate. We want
So
to
that
solve the
means-
problem within
right.
the community,
so
and I
give me
think
a second.
we're doing
Hold on,
that.
wait. You're going. Give me a moment.
You know me.
You answered
I'm
my
going.
first question, which is
Outstanding.
you don't know. So on average, the prosecutor who is elected in certain counties is only there for 4 years. So as somebody who says that they believe in smaller government and not big government or infringing on someone's right, do you believe that it is proper protocol to infringe on another elected officials or another elected bodies who may have been serving that term? Do you think that that's appropriate?
I think we have a problem, and the problem needs to be solved.
So that's not answering the question. So the question was, and maybe I should restate it so that
Sure.
we can understand what I'm saying.
Sure.
So if you've got somebody who's elected for 4 years, right? And then someone who is overseeing for 5 years, and this person who is serving for 4 years does not get elected for that 4-year term, and another person comes in and gets elected, do you think that it is appropriate for that other person who was elected for that another term to have someone oversee for an entire year their term?
I think we need to limit the backlog of cases in that area, and actually the prosecutor needs to start prosecuting and move the process along so that we
Okay.
can clean up the streets.
So yeah, you're not answering the question. That's fine. All right. Another question I wanted to ask you in saying that if we've read the bill and you believe that this bill came out and it is a good bill because it was vetted by the committee, are you going to support the underlying amendment to the amendment?
No, I would like to see 5 years be retained.
No, not the amendment to the amendment, the underlying amendment. Are you going to support the gentleman for Jasper's amendment because he's making changes that we already as a committee, because we serve on that committee together, that means that you thought that that bill was the best bill that we could produce as the committee, so you're not going to support his amendment either?
I've looked at all of the amendments that are being added currently, and I said earlier, you don't throw the baby out with the bathwater, and I retain that statement. I think we really need to do something to help the people in the community, particularly in St. Louis, and I think this bill, in its current form, can do that, and I don't think this amendment is necessary.
And the other amendment that goes with it?
The other amendment that goes with it?
So-
Are you talking about the bill in totality, the amendment
No.
to House Bill 301?
Okay, so you know that this is an amendment to the amendment.
Absolutely.
Right, so the other amendment, you don't support that amendment either.
No, I think we're doing right by doing some of the amendments that we've already discussed today. Sure.
That's a little hypocritical because you said that the
Well,
committee...
nothing's perfect.
Hold on, wait, but give me a moment. You said that you, and I quote, and you keep saying it on the floor, that the committee did its due diligence.
We did.
We should not be changing anything. No other amendment needed to be added. So that means, gentlemen, as a person who says he is of his word, that you are not going to support the underlying amendment to this amendment either.
Lady, I wish we lived in a perfect
Well, I
world,
guess
but
not.
we don't.
Mr.
There's no
Speaker, to
perfect
speak
bill.
on
Thank you.
the underlying amendment to the amendment.
Please proceed.
Thank you, Mr. Speaker. I just want us to point out the hypocrisy of this all. You have somebody who decides they're going to stand up every single time and say that they're going to speak out against an amendment because the committee did its job, but yet says they're going to support the other amendment because the committee did its job. As someone who understands that you do not want someone to infringe upon your right and the constituents' right who have elected you to that position, it is the same as saying you as a state representative, if you were serving for 2 years and someone appoints a special representative to your district and they get to serve 3 years and you're reelected, that means you only really get 1 year to serve. That is ridiculous. We should not, by any means, be willing to infringe on people by saying that they have 5 years to serve when the position itself only serves for 4. I encourage the Speaker and the body to support the amendment. Thank you.
Further discussion on House Amendment 8. Gentleman from Pike, from a microphone other than your own.
Thank you, Mr. Speaker, to speak on the amendment to the amendment.
Please proceed.
Mr. Speaker, given the nature of the amendment to the amendment, I would ask if I could get 5 members standing, we would have a roll call vote.
I see 5 members standing. You'll have your roll call vote. Further gentleman from Jackson.
Thank you, Mr. Speaker. I move the previous question.
The gentleman from Jackson has asked that shall the question under immediate consideration be now put. All those in favor will vote aye. Those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 105 yea, 39 nay, you have moved the previous question. Gentleman from St. Louis, you have 1 minute to close.
Thank you, Mr. Speaker. I appreciate the bill sponsor support. I know we had conversations about this. I think this is a great way to make sure that we don't infringe on St. Louis city rights and the rights of the people that are trying to do the right thing, and if potentially a new person comes in, to not kind of tie their hands behind their back. So with that, Mr. Speaker, I close.
The gentleman from St. Louis has moved for the adoption of House Amendment 8, House Amendment 1. A roll call vote has been requested. Mr. Clerk, all those in favor will vote aye. All those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 37 yea, 107 nay, 2 present, you have failed to adopt House Amendment 8 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Jackson.
Thank you, Mr. Speaker. I have an amendment ending in .89H. It's been distributed, and I move for its adoption.
The gentleman from Jackson has moved for the adoption of House Amendment 9 to House Amendment 1. Gentleman from Jackson.
Thank you, Mr. Speaker. This is the technical fix for the gentleman from the Andrew District. That he had pointed out that mistake, or that he considered a mistake, but it has been fixed. This is the original amendment that we heard earlier for Blair's Law, and we'll be glad we'll be able to fix it, which we have, and we also appreciate the body's support if they could vote for this amendment. Thank you.
Further discussion on House Amendment 9. Gentleman from Andrew.
To speak on the amendment to the amendment.
Please proceed.
I praise my colleagues from across the aisle for fixing this amendment. I don't. We often say words have meaning, and they do. And I thank you very much for fixing this amendment and making it right. I will be in full support of this amendment, Mr. Speaker. Thank you all very much.
Further discussion on House Amendment 9. Billington. Gentleman from Butler.
Mr. Speaker, to speak on amendment to amendment.
Please proceed.
I Probably everybody know that I normally vote no on the other side of the amendment, but they're really a good amendment. So I would appreciate the body vote yes.
Further discussion on House Amendment 9. Gentleman from St. Louis.
Thank you, Mr. Speaker. To speak on the amendment.
Please proceed.
I won't take up everybody's time. I mean, this is probably one of the most simplest bills that has come through this body. The gentleman has worked very hard for the past several years since me and him first entered this body to make sure he addressed something that you talk about public safety. Let's make sure we address something that can actually impact. You want to talk about the areas that need the help the most. This is something that one of the toughest communities outside of St. Louis is asking for, so that they can have a little bit more protection and help in their area. The gentleman even took the time to try to fix, when you talk about bipartisan and working and almost just like bending over sideways to fix the potential issues in this bill. He did that because someone from the other side said, hey, there was an issue. Thank you so much to the gentleman for being a class act and continuing to work on this. As a body, I would ask that we support this amendment. It's the right thing to do. It's a bipartisan amendment. We've done it plenty of times before, so I would ask the body to support it again. Thank you.
Further discussion on House Amendment 9. Seeing none, gentleman from Jackson, you're recognized to close.
I'm glad that we were able to fix this, and with that, I renew my motion.
The gentleman from Jackson has moved for the adoption of House Amendment 9 to the House Amendment 1. All those in favor, please signify by saying aye. And those opposed, no. And the ayes have it. You've adopted House Amendment 9 to House Amendment 1. Further discussion on House Amendment 1. Gentleman from Jackson.
Thank you, Mr. Speaker. I move the previous question.
The gentleman from Jackson has moved that shall the question under immediate consideration be now put. All those in favor will vote aye. All those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Everybody voted. Mr. Clerk, please close the board and tally the vote. By your vote of 106 yea, 39 nay, you have moved the previous question. Gentleman from Jasper, you have 1 minute to close.
Thank you, Mr. Speaker. Just for clarification purposes, I want to point out that the lady from St. Louis, we had a lengthy discussion about the firearms. She did her level best to try to find a way to make this palatable for both sides. It was a very difficult issue. I want to point out that her passion is based on the fact that she lives this every day. It is just not a simple question, like many things that come before us. Yes or no buttons aside, most of the questions that we face are not yes or no. And I appreciate that. I also want to say that I understand the reluctance on some parts regarding the special prosecutor. But, Mr. Speaker, if someone says to me that St. Louis is what St. Louis is, it's always been this way, whatever we do is not going to make any difference, I absolutely reject that. I've spent an entire life standing between victims and the people who had victimized them, and I refuse to accept that there's nothing we can do. I renew my motion.
The gentleman from Jasper has renewed his motion for the adoption of House Amendment 1 as amended to House Committee Substitute to House Bill 301. All those in favor will vote aye. Those opposed will vote no. Mr. Clerk, please ring the bell and open the board. Has everybody voted? Mr. Clerk, please close the board and tally the vote. By your vote of 100 yea, 31 nay, and 13 present, you have adopted House Amendment 1 as amended, House Committee Substitute to House Bill 301. Further discussion? Seeing none, gentleman from Jackson, you're recognized to close.
Thank you, Mr. Speaker. I renew my motion.
The gentleman from Jasper has renewed his motion that House Committee Substitute for House Bill 301 as amended be adopted. All those in favor signify by saying aye. Aye. And those opposed, no. And the ayes have it. You've adopted House Committee Substitute to House Bill 301. Gentleman from Jasper, you're recognized to renew your motion.
Thank you, Mr. Speaker. I renew my motion.
The gentleman from Jasper has renewed his motion that House Committee Substitute for House Bill 301 as amended be ordered perfected and printed. All those in favor, please signify by saying aye. And those opposed, no. And the ayes have it. You've ordered House Committee Substitute to House Bill 301 as amended, perfected, and printed. Gentleman from Jackson.
Thank you, Mr. Speaker. Next order of business will be announcements.
Announcements. Gentleman from Pulaski.
Thank you, Mr. Speaker. Your Committee on Emerging Issues will meet in approximately 10 minutes in hearing room 6.
Gentleman from Randolph.
Yes, your committee on subcommittee on education appropriations will meet in hearing room 1 immediately following.
Thank you. Gentleman from Washington.
Mr. Speaker, your committee on Ways and Means will meet in the morning at 8 o'clock in hearing room 5.
Gentleman from Urban Coal.
Your Committee on Corrections and Public Institutions Committee will hearing in 10 minutes in hearing room 1.
Gentleman from Green.
Mr. Speaker, your Appropriations Subcommittee on Public Safety will meet tomorrow morning at 8 a.m.
Gentleman from Pulaski.
Thank you, Mr. Speaker. Committee on Transportation Accountability will meet bright and early at 8 o'clock in the morning.
Lady from St. Louis. Lady from...
Thank you, Mr. Speaker. A brief announcement.
Please proceed.
Thank you, Mr. Speaker. I just want to say happy birthday, Auntie Marion. She just turned 99 this week. So we love you, thank you, and happy birthday, Aunt Marion.
Happy 99. Lady from St. Louis Walshmore District.
Thank you, Mr. Speaker. Announcement.
Please proceed.
This year's first meeting of the Irish American Caucus will be meeting upon adjournment in H.R. 2. Don't worry if you have committee. We will be continuing at Patty Malone's later this evening. Catch up with us there. Thank you.
Further announcements. Gentleman from St. Louis.
Yes,
County.
Mr. Speaker. The J House Social will start at 7:30.
Further announcements. Seeing none. Gentleman from Jackson.
Thank you, Mr. Speaker. Upon return, members should be prepared to perfect House Bill 14. Members should be prepared to consider House Committee Substitute for House Bills 115 and 301. And with no other business before the body, I ask that the House stand adjourned until 9 a.m. Thursday, February 9th, 2023.
The gentleman from Jackson County has moved that the House stand adjourned until 9 a.m. Thursday, February the 9th, 2023. All those in favor, please signify by saying aye. And those opposed, no. And the ayes have it. The House stands adjourned.